Okay, let's call the meeting to order at 10 after 4, 4:10. Please call the roll.
Matthew Cate.
Present.
Lila Hood.
Present.
Josh Wolf, noted not present. Luam Tesfaye.
Present.
Frank Canada.
Present.
Chris Highland, noted not present. Fiona Hinsey.
Present.
Present. Chair Wolf.
Present.
We have a quorum.
Okay, I just want to notate that Vice Chair Highland has had some special conditions which caused him not to be able to return to the States. So I'm going to notate that for the record and that he be excused. Okay. Yes.
I have some
Any changes to the agenda?
changes to discuss today's meeting.
Go for it.
We did receive a email notice from Mr. Don Chan, item number 7, from the respondent that they are having emergency medical issues and are unable to attend. I have not seen Mr. Don Chan. However, I believe we should just wait for him and discuss it with him when he enters. And regarding item number 3, Julian's car, we received an email from him about an hour ago stating he had an emergency with Superior Court at 3:30, and he was going to try to get there as soon as possible. My suggestion would be to take items out of order and give him until approximately 5 o'clock to appear before continuing the matter to a future date. The respondent is here, but she does need to leave for another engagement by 5:30.
Okay. That sounds reasonable.
Yeah.
Let's, as to the changes in the adjustments to the agenda, is there any objection to that? No objection to it. Is there any public comment on these changes to the agenda? None? Okay. Shall we, let's make it, let's take an action on that so we can move everything up. Is there a motion to
Yes,
adjust
so
the
moved.
agenda?
Second.
Been moved by Member Canada, second by Member Cate. I ask for public comment. Again, any additional public comment? Seeing none, can we take that by acclamation? Seeing no objection. Okay, those items are adjusted today's agenda. So let's call the, is there any other adjustments?
Those are the only adjustments.
Okay.
I believe the next item on the agenda would be item 5 and 6. They were called and heard together at the committee. I don't know if they would like to do that at the full task force.
Well, we need to approve the minutes first.
Oh, my apologies.
Please call item number 2.
Item number 2, approval of the minutes from the Sunshine Ordinance Task Force August 1, 2018 meeting.
Okay, members, any changes, adjustments to the agenda, the minutes from last meeting? Okay, hearing none, is there a motion to approve?
I motion to approve.
Moved by Member LaHood, second by Member Canada. Any public comment on the minutes? Seeing no public comment, can we take that by acclamation? Seeing no objection, item is approved. Please call next item. This would be item number 5.
Item number 5, file number 17129, complaint filed by Patrick Roddy against the Department of Public Health for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner.
Okay. Let's see where we are with this one. Okay, Member Canada.
Yeah, so this came to Compliance and Amendments Committee, and the meat of this is that the Department of Public Health states that they're not allowed to release this information and only the state can release it. We decided to send it up here pending an opinion from DCA COLA about the Sunshine Ordinance or state law having superseding each other, or one superseding the other, and DCA COLA on August 24th did send out an email on it.
Okay, great. So just for everybody's refresher, this item has already been heard by the task force. We have testimony from all parties involved. This was referred to committee for further compliance. Committee did its due diligence and has referred it back to the task force for final determination. So we're now at the place of where it's back on the table for the task force members. And if there are any additional questions for any of the parties or clarifications you need from council, we can move forward with a motion for determination. So maybe Member Kanata, based upon the information that we received from DCA COLA, maybe you want to explain where we are now.
Yeah, I mean, DCA COLA's memo basically states that, it states the Sunshine Ordinance allows withholding under basis specified in CPRA. This is referenced in the opening lines of 6724 as well as 6727. Also cited below CPRA section 6258K, which allows for exemption pursuant to federal or state law. As such, if the Health and Safety Code, which is state law, calls for an exemption or prohibition to disclose, it supersedes the Sunshine Ordinance.
Okay.
So,
we did ask the Department of Health to provide some information.
and I believe Mr. Roddy, is this the item where you and the department were supposedly going to try to work together to get information? Yeah, please.
I've had nothing but a year of stonewalling for the Department of Public Health. They have not helped in any way except, go ask the state. And the only thing in state law that they say applies is a law that does not apply. It says you can't give out the entire indice comprehensive. I'm not asking for comprehensive, so this memo from the city attorney is flawed. It's on bad information. The state law does not apply. So anyway, I could go. I could speak longer about it.
Thank you. Is Ms. Campos here? Somebody from the Department of Health? The respondent is not here.
From here earlier, I think she went out and took a phone call, but maybe she
Okay.
might think because of the agenda, she might have.
All right.
I'd give her time.
Thank you, Mr. Roddy. Member Kanata, so the task force had asked a couple of questions, a few questions. One is there any information that's maintained by the city and county that is being withheld with regards to, related to records of death? Can San Francisco numbers be provided regarding death over a certain time period from any records that's maintained by the city and county? And how does the Health and Safety Code section 102231 apply to these records? Are these records specifically classified, and how are they classified, that kind of thing? Were any of those questions
I don't think any of the questions were answered fully. I don't think that they had a representative who knew
Okay.
all this information.
We don't have any written response
No.
from the department on that? Okay. All right. Since the respondent isn't here, I'd like to move our agenda forward. Maybe we could table this item until somebody from the department shows up. We can.
Like I said, that's also on there.
Right. So we can give it. I mean, we're already pushing back a few others, but we.
So we would do this and the next item then, because it's the same issue, same department.
Oh, so both. All right. So do we have any other items on the agenda then? That are.
Deontay Walker and Tamara Reed, item number 8.
Cannot hear that until 5:30.
Okay.
Okay, so let's do this. let's have a motion to table this item until,
Is it possible, Mr. Roddy, you know this person by sight, do you want to go in the hall and see if they're here? Maybe they're just
Okay.
outside and doing a phone call,
all
like
right,
you
'cause
said.
otherwise I'll move to, well,
Well, what about item number 7?
item number 7. That's the
That's
one
the
that
one,
got
okay.
that got moved to 5:30. Otherwise,
And
we could do all the other items that are not, because they're not action items. Well, they're at the bottom of the agenda. Are they here? Okay, great. Perfect. Excellent. So we can continue with this item.
Yeah, and what I remember from, it was either the full task force meeting or the committee's meeting, was that there are records that are held within the city, but my memory is in not one spot, different, the morgue and different areas of the city provide information to the Department of Public Health.
That's okay. This particular, let's be
Okay.
specific, because you have multiple complaints by the same complainant on different departments, and we have different issues with regards to them. This particular one is to DPH, so let's keep it focused on that. If they don't have they have some records, but not other records that are located somewhere else, we'll deal with that when that comes. Is the representative, the respondent from DPH here now? Department of Public Health? No? Okay. All right. Well, then let's table this item until after 5:30. We'll have to take these as respondents appear, or complainants appear, and we'll take them in that kind of order. Can we have a motion to table this item?
Yeah, I moved to table it.
Okay. Moved by Member Kanata, second by Member Tesfaye, and this would be to table the item until the respondent appears later in the meeting today. Is there any public comment on the motion to table this item? Seeing no public comment, can we take that by acclamation? Seeing no objection? Okay. So all our cases are now tabled. Let's move, and public comment doesn't come till 5 p.m., so let's take care of some of the items at the bottom of the agenda. Let's move to item number 9. Go ahead.
Item number 9, Sunshine Ordinance Task Force 2019 meeting schedule.
Okay, so this is a proposal, but this is also based upon room availability in the building. So everybody has had a chance to take a look at it. If there are any concerns or changes that you think you might want to do, or you might want to have or suggest, now's the time. Maybe our administrator has something
Yeah,
to, one of the administrators.
The only thing, I don't have my
Member Kanata.
calendar in front of me, but it's November 19th, Tuesday before Thanksgiving. Or-
We placed all the dates on the agenda.
Yeah.
And leave it up to you to make those decisions.
Yeah.
This is for 2019, not for 2018.
Right. Okay.
Go ahead, Member Tesfaye.
I know that we are going to be shuffling the membership of the committees in the coming months, and so I have some concern about approving these meeting dates if the committee members change. So I'm wondering what you think we should do to address that.
Well, this is a proposal for now. We don't, are you,
Based on our current schedule, it can change at any time.
right?
Okay.
So as long as we stay with these dates, these are the room availability dates,
it.
we can shuffle the committees times around.
Great, thank you.
Yeah, we can definitely do that. We've done that before, correct?
Yes.
Okay, great. Anything else to add on the schedule?
It's just when we get to our administrator's report, we would like some help with assigning of membership. I know we do need to wait for new appointments before we can make solid changes, but just for the upcoming months, we do need some additional members for the committee.
Right. All right, I get that. And we'll have, Member Highland will be back next month.
And then we would
So-
also need to discuss the holiday schedule for November and December.
Of this,
During the administrative report, we can discuss
we can do that then. Okay, great. Is there anything else for the good of cause on this? This is for Member Josh Wolf, just arrived at 4:24. We're going over the schedule for next year.
Okay.
Is there anything you want to notate? Okay. All right. Is there any?
No action is needed on this matter.
Great. But I'll take any public comment if there's any interest in. Okay, seeing no public comment. Okay, let's call the next item.
Item number 10, Sunshine Ordinance Task Force Annual Report.
Okay, so the annual report is included. This annual report actually is annual report for 2016 and 2017. There's a little bit of a misunderstanding as to what we were behind with at the time, considering the lateness of some of us coming into our position, and half the report already had been done by the previous chair, and so this is for 2016 and 2017. 2017, 2018 is still in draft and will be forthcoming. If anybody was here during this period of 2016, 2017, has anything to add to it, be happy to do that.
I have one point of clarification. On the complaint committee section, it lists the members of the committee as myself, Member Hinsey, and Member Baranetsky. I know that there was a period when Member Baranetsky was no longer on the task force, and you, Chair Wolf, were filling in. So I'm not sure if that happened in 2018 or 2017, but that might be a point of clarification, and that I think
Okay.
it only appears one time that way.
Okay, we can make that amendment. If you make a note of that, Cheryl. Is there anything else? I know our legal counsel wasn't here at that time. I don't know if there's anything that pops out for you. Nothing? Okay, great. Okay. With that change, can we move to adopt the report and send it up to the Board of Supervisors?
So moved.
Moved by Member Tesfaye. Is there a second?
Point of clarification before I second that. So we're just moving this part up to the Board of Supervisors?
Yeah, it's just for 2016, 2017.
Will they be moved up separately?
Yes,
Okay.
2017, 2018 will be another one because we're trying to fill out some of the highlights from the year and adjustments in the membership.
All right, okay.
There's still some edits that need to be done on that one.
Second.
It's moved by Member Tesfaye, second by Member Hinsey. Is there any public comment on the annual report? Seeing none, can we take this by acclamation? Seeing no objection, item is approved. Let's call the next item.
Item number 11, reports from Sunshine Ordinance Task Force Committees.
Okay, Complaints Committee, any reports?
No.
Compliance and Amendments Committee? Education, Outreach, and Training?
No.
Rules Committee?
We will be meeting in October sometime, I think. If you have any items.
Okay.
I think here comes Victor, possibly.
Again, we have the issue with the membership. There's currently only one member.
Oh,
Actually,
right.
with Mr. Highlander, Vice Chair Highlander will be two. We are thinking about scheduling it prior to the complaint committee meeting this month on the 4th Tuesday of the month. We do have a draft agenda, and if there's any other ideas that you wish to consider, we'll be happy to add it. And we will pass that agenda around tomorrow by email. And if there's no objection, we can schedule a 4 o'clock meeting on the 4th Tuesday, prior to the
Great.
complaint committee meeting.
Okay, great.
And
And if,
we'll need another member, I guess.
yeah, if Vice Chair Highland's not back, then I'll step into that. Not a problem. Unless somebody else is interested in sitting in on a rules committee, doesn't meet that often, but it deals with our policies, procedures, and bylaws.
I mean, I'll be here for the complaint committee, so I can come.
Okay, great.
It's
Okay,
the
great.
23rd, right?
I
think that's
believe so.
The 4th Tuesday?
4th Tuesday of the month.
Yep, sounds about right.
All right, great.
Thank you. Good.
Very good. That's good.
And the Information Technology and Ad Hoc Committee?
Just a minute. So I just want to, at this point, ask if there's any public comment for any of these committees, since these are standing committees. Okay. Yes, you have comment? No comment. Okay, great. The next one is. Go ahead.
Information Technology Ad Hoc Committee.
So this hasn't been meeting. We're kind of waiting to hear back from the clerk as to what's happening with their legislative database platform to see if we could be included. I don't know if there are any updates on that. No, they're still reviewing and the platforms. One of the things that we're very interested in is trying to contain at least to start all our orders of determination and have them searchable and possibly tagged or categorized, so make it easy for us when we're preparing for meetings to review past decisions that we've made. It helps staff in providing notes and also legal counsel in finding information faster. In providing their reviews, and it helps us not reinvent the wheel or spend a lot of time, trying to decide whether we've taken positions on this before, and if there have been, and it's kind of a standing position, it makes it a lot easier to understand what the context was in history, somewhat like our case law compendium, which we should have easy access to. Okay, is there anything other members not on these committees would like a committee to take a look at? Seeing none, I'll open it up for public comment. If there are any members of the public that have any suggestions or interest to comment on anything for any of the committees. Seeing none, okay, let's move on to the next item.
Item number 12, Sunshine Ordinance Task Force Chair's Report.
The only thing I have to report is we are trying to move the Board of Supervisors Rules Committee to finish making appointments to the seats that are vacant. Many of us are holdovers now for these seats, and to fill in the rest of the empty seats. Do you have something to report?
Yes,
Victor?
I'd just like the members to be ready for a possible October 24th meeting, which is the next date that the Rules Committee will meet. They do not send out notices until the Friday, the week before the meeting. So you'll probably only get about 4 or 5 days notice at the most. But their next meeting date of the Rules Committee is the 24th.
So that's a Wednesday?
Yes, they meet Wednesdays at 1 o'clock.
1 o'clock, okay. So you need to tell your offices that you need time off. You got plenty of time.
It's October 24th.
October
That's
24th.
the next potential date, which is a good possibility.
And we can, as it gets closer, we can check in with the scheduler to see if that's happening. Member Josh Wolf.
What, if anything, is the What, if anything, is the best protocol if we already know we will not be in the area on the 24th?
Is to notify the Rules Committee directly.
Ahead of its scheduling, or?
Once you get notice, contact the chair of the Rules Committee, which would be Catherine Myers. Let her know that you're out of town and you're an incumbent, and see how she wants to deal with it.
Yeah.
But
Their discretion.
but wait for it to be scheduled.
Yes,
Wait.
because the schedule hasn't been set yet.
Right.
Wait a second. Who's the chair of the Rules?
That's
Safai.
Safai,
Yeah.
and Catherine Meyer is the legislative aide who handles the scheduling on behalf of the chair.
Right.
Great.
Yeah, you let her know, and there's, sometimes you can send in a written statement, everybody gets to read it beforehand and accepts that as your kind of presentation, that kind of thing. All right, anything else to be said on this item?
No.
Okay. The only other thing I wanted to mention is, as maybe some of you know, there's a ballot initiative on this November's ballot, Prop B, the Privacy First ballot initiative, and the meat of that initiative, it's a charter amendment, and the reason why it's a charter amendment is because it's providing specific authority at the highest level to the city administrator to provide policy or regulations in administering contracts and other departments with regards to permits and what have you. Anybody that does business with the city or the city gives allowance or privilege to by some sort of official motion or permit. What it's asking to do is based on a set of guidelines and principles to protect people's privacy when these entities are doing their business in collection of information. So if there's a contractor that is contracted to provide certain service and it requires information about the users of that service who are members of the public, there would be a set of parameters that are based upon these guidelines and principles that whoever is providing the contract under the supervision of the city administrator, they would have to abide by those. If they go outside of those parameters, then there would be noncompliance. It could be a violation. There could be penalties, so on and so forth. And this is to, try to protect and confine the amount of information collected to be only for that particular purposes, and that they cannot be sold or shared for any reason. So the principles and guidelines are not really part of the charter amendment. They're to be applied when the administration of these current procedures are in place. But in a singular section that would be part of the charter amendment, it would allow adjustments, amendments to various different laws regarding public disclosure, open meetings, including the Sunshine Ordinance, by the Board of Supervisors. That would also then need to be approved by the mayor under the regular legislative process. And so that is a departure from what is the current state of things, where the Sunshine Ordinance can only be amended in a substantive state by the voters. There are some rudimentary and sundry items with regards to minimal procedures that wouldn't change the ordinance that the Board of Supervisors can make amendments to, which is done before. Like when the Prop 95 calendars came out, that obviously had to be amended, as kind of pro forma because it was part of state law. Things like that, which would have had to be done anyway, so it's just kind of automatic. But here it would change that. And so there's been lots of commentary on it. I don't know if anybody has any concerns or questions about it, but I felt at this point it was important to report it. Unfortunately, we were not made aware of it as an official body, and I had to learn about it through other means myself. Maybe other people read about it in the newspaper, or they heard about it through the Ballot Simplification Committee when it came to that meeting, so on and so forth. And Member Josh Wolf.
So 3 quick things. One, I think it's important to note that we have 2 former task force members who have very different views on how this law would actually be implemented. Former member Rick Nee strongly feels that this would allow the supervisors to roll back protections. And Lee Hepner, who is a staff member for Supervisor Peskin, strongly feels that this would allow the Board of Supervisors to increase protections, and that the language built in around intent of the law or something of that nature, I don't have it in front of me, is a stop back to prevent it from the Board of Supervisors from decreasing the protections afforded under the Sunshine Ordinance. So I think it's important for us, to whatever extent, to have some sort of impartial interpretation of that would be great. I don't know whether our city attorney representative can weigh in on their interpretation of that or not. And the final point I want to make is I don't know exactly what our role as task force members is in regards to media inquiries about this matter. But I do know that at least one outlet has approached me, and I essentially deferred them to reach out to you as the chair, because I also have a past relationship with the publication, as does another member of the task force. But I think, given that this does so closely co-align with the Sunshine Task Force, and we may have additional media inquiries, it's probably good for us to at least get on the same page as to what that procedure should be.
Okay, so a couple of things. One is I did have a meeting with Supervisor Peskin and Legislative Aide Lee Hepner on this matter after it had gone through, and we found out about this afterwards. That meeting was with former chairs Rick Nee and Allison Washburn. And frankly, from what I understand is almost every chair prior is opposing this, and there's a kind of a long list of good government advocate organizations, and some of which were the framers of the Sunshine Ordinance in late 1990s that are also opposed to this. I was interviewed today by Public Press, and my position with them was that task force has not talked about this, discussed it, reviewed it, so it has no position on it at this time, but that we were not informed of it as we had been informed of other potential legislation that might affect us in the past. That has been without provocation presented by the proponents of those legislation or those bills. But this time for this one, which is a direct effect on the task force and how and what we do things, we had not been notified that this was going to be happening prior. Now, granted, this was all done in the public's view. It was agendized and introduced to the Board of Supervisors. It did pass through quickly through Board of Supervisors, and there was at least one hearing, but we were not notified. It did not come up on our radar at all, as you would think it might. So that's really kind of the balance of where things are at right now. how individuals want to take a position in your own personal views, that's up to you. But as a body, we usually don't take positions on this, but we very much would at least like to comment and be part of the development of such things. We can pose if you want to, we could pass a resolution if you wanted to take some sort of, want to make some sort of declaration about it. We've done those things in years past. It's not often that we do those things, but it's up to you folks what you want to do. Member Josh Wolf.
How can we pass a resolution on it when this is the October meeting? It's not agendized on this meeting, and the next meeting is the day after the election.
Right. Well, that's true. That's true. We probably couldn't. That's what I have to report on that. Yes. Okay. So I don't have any other items to report, except I did ask at the previous couple of meetings about committee changes. People wanted to kind of play musical chairs. They wanted to get a different view of things. If anybody wanted any changes, they could let me know. Remember,
I was just going to say that we should probably wait until the next Rules Committee meeting when people are reappointed to see it.
The Board of Supervisors Rules Committee.
Right.
Yeah.
Right.
Okay, we can wait on that. All right. Is there anything else in my...
There's an EOTC meeting this month, and I'm not sure there's any actual members other than myself on EOTC.
When is it?
It is...
Education, outreach, and training.
Yeah.
When-
She asked
EOTC.
when it is.
The 16th, I believe.
I think that's what you told me.
Yeah.
Yeah, that's the Tuesday.
16th of this month. Fiona.
At what time?
3:30?
Or 4. We made it earlier, but it doesn't matter at this point. So we made it earlier a couple years ago under a different pretext.
Yeah, I believe the meeting starts at 3:30.
I believe we can discuss this under the administrative.
Oh,
or
okay.
the schedule is listed.
Okay.
Okay.
Okay, go ahead.
All right, great. Okay, I have nothing else to add. Is there any public comment on the chair's report? Seeing none. Okay. Let's move to the next item, please.
Mr. Chairman?
Yes.
I believe we do have the representative from Public Health here at this time.
Okay.
However, would you like to take action on item 3 to continue that matter to the call of the chair? It's 4:45. The complainant is not here, and I'm not sure if they will make it from Superior Court, or do you want to wait a little bit longer?
I would just say let's let it hang as tabled, and when we get towards the end of the meeting, if they still aren't here, then we'll decide how to dispense with it. Okay. All right. Great.
I believe we're back to item 5.
Okay.
Would you like me
So let's
to
just
reread
make
that?
sure, are both parties here? Department of Public Health? Okay, great. Okay. Let's call item 5.
Item number 5 again?
Yeah.
Item number 5, file number 17129, complaint filed by Patrick Roddy against the Department of Public Health for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner.
Okay, so we had already started some discussion on this, just to bring Department of Health up to speed. We got just an update on what this was about from our chair of the Compliance and Amendments Committee. We ended with some of the questions that the task force had asked for, but were not answered either through the committee or in writing. So we want to ask the respondent now, the Department of Health, a few questions. If you can come up, please. State your name, please.
Linda Acosta from Public Health Department.
Okay, and Erica Campos is not available?
No, unfortunately, we just got this meeting sent to us by email, and normally I think that you reach out to us and say,
Oh.
They're unable to be here.
Okay. So before we move on, I want to make sure that you have the ability to answer some of these questions.
Depends on what you're going to.
Right. So I'm going to ask them to you, and if you're not able to answer them, then we'll have to decide what to do at this point. So we had asked some questions of DPH related to the processing of and filing of records related to deaths in San Francisco. First question is there any information maintained by the city and county that is being withheld in relation to records of death?
Is there anything that's being withheld? No, not what Mr. Roddy is requesting.
Are there any records at all related that are held?
No.
Okay. Can DPH can you provide San Francisco numbers? Can you provide numbers regarding death over a certain time period from current records?
I'm sorry.
Bless you.
Are we talking about, which file is this? Is this about?
We don't know what files exist. That's what we're trying to ascertain here, if there are any files.
Are we referring to the case in which Mr. Roddy's asking for deaths per day?
I'm sorry, hold on a second. Yes, member?
In our items.
Sorry?
File
I think
number?
she's asking for
Oh.
our file number.
File number
Yeah.
17129.
This is for 17129. This is not for the next item.
Okay. So, and sorry, will you repeat the question?
So, can numbers from within San Francisco be provided regarding death over a certain time period from records? No. Okay. And how does California, you've cited California Health and Safety Code 102231. How does that section of code apply to records being maintained by the city and county?
So, in today's packet, I believe there's an email from City Attorney Nicholas Kalla saying exactly how it applies.
Right.
I don't have a copy with me.
Right. So the question we have is that would suppose or presuppose that there are records, the records do exist.
They're not our records, and we're not free to give them out.
Okay. So they're not, but are they in your possession?
Again, we have a database. We don't have any reports, so we do not have records that Mr. Roddy requested.
If you're able to see something on the screen, are you able to print it? Do you print it?
I don't print it.
Are reports made to?
No one prints them.
Okay. Are reports made to the Health Commission with regards to deaths in San Francisco?
I don't believe so.
Okay. Are reports made to any other employee or staffer or department head with regarding deaths by city staff or divisions or departments?
Not that I'm
From
aware of.
Okay. If you were, when records and other records that are applicable to this section that you do have that are not releasable, how do you classify them? What litmus are they given so that they have a status that would be applied to this particular section for withholding records? So if you have records, and your legal counsel or some other analyst needs to determine whether they are releasable to the public or not. We always consider things to be public information if they're created or collected by the city and county. So of records that are either not releasable, records that can be withheld, or information on the records that could be redacted, is there a process? Is there something written down, some sort of
Sure.
procedure that does that?
The city attorney's office has a good government guide, so we follow that, and know what that we must redact from any sort of document that we release, and that includes, personal information, cell phone information, personnel records. I think you're familiar with all the things that need to be redacted. If we had any sort of question on that, then we would refer back to the city attorney and say, hey, does this need to be released or not?
Okay. All right, great. Members, Member Josh Wolf.
So when you put the information, you notify, I think the last time we were here, it was a state agency that receives the notification of a death?
The state agency owns the database, and we go into it and check
Right,
off
yeah.
saying it's complete.
Right. So when you update that database, does it generate a receipt or any sort of acknowledgement that the database has been updated that is sent to you in some fashion?
I don't know if it does. I've never heard of anything like that.
Okay, but you can't say that it doesn't at this point. You just aren't sure.
I can say that I believe Erica, the last time she was here, would have said that there was something if there was in fact a receipt. I don't believe she said there was a receipt. I'm not aware of any receipt.
Okay, thank you.
Member Knapp.
So just so, and I think I understand the process as described the last couple of times, but correct me if I'm off here. So somebody dies and some city department, the coroner, a hospital, somebody sends in some type of information to your department saying there's been a death? Or how does the information get to your department?
So it's not to the public health.
Public
department.
health.
So it is in a database. I don't know if people in the records department check the database every day. I don't know how they're notified.
But and this is the state-owned database that you're talking. So if somebody dies in the city and county of San Francisco, you're saying that somebody gets into this state database and logs that death.
They don't log a death. They look at the record and make sure that everything's been done.
But how does the record get started? You're saying there's a database that the state owns. If somebody dies in San Francisco, how does the state know that person has died?
So one of the other people that are involved in the process, and again, this is not my department, so forgive me.
But it's still the Department of Health.
It's the Department of
Okay.
Public Health. It's one of our many, many, many
Okay.
departments.
Mhm.
So from what I understand, the either the mortuary or the physician of record will record a death.
In the state database or with the city of San Francisco?
It's not with the city of San Francisco. That I know. I don't know how it shows up in the database, but they record a death. It's not the city that records that death. Not my department.
Who presses the keyboard? Who presses the buttons on the terminal to record a death?
It's not my department.
Now, I understand, but you're not, so you're representing the entire Department of Health here, not
Yes.
your department?
Yes.
Okay. So the question that then we have to ask is, are you familiar with this process?
I'm familiar enough to know that we do not generate that record of death.
You don't generate it. So again, going back to Member Kanada's question, how does it end up at the state level?
Either a mortuary or a physician on record will record a death, and they record the time of death and who it was and all sorts of information related to the death.
So let me ask, if an investigative reporter was doing a report on deaths in the city, and there's all kinds of articles you can probably do a search for that notates how many deaths there are for either the entire city or specific demographics. Where do they get? Did they get that information from you?
No.
Okay.
So I know that I've run into reporters at our vital records department looking for information, and a lot of times they'll purchase records, and they will have some bit of information so that they can purchase that record.
Would there be records in there around deaths in the city?
Are there records there? Sure. And so, family members can come and get their, family member's death record at the window for a charge of $22 or whatever the charge is for a death certificate.
Okay, so death certificates are managed by the city?
We print them out for people who request them.
Okay, so you do have records of death?
When $2, yes.
Through the chair, is this record in the state database or in the city database?
State database.
Okay, that's fine,
I just
that's
wanted to
fine.
be clear with that.
No, that's fine, but, you know, a certificate of death is a record. And if it's a record that can be gotten, that is, you know, distributed by and available here in the city, anybody could then ask for it, can they not?
So if it is available to that person by law, then yes, we release it. If it is not available to the person by law, we do not release it. In this case, it's not available by law to the person requesting it.
Are you familiar with the law?
Yes.
Can you briefly describe it for us?
So it's in the packet. It's in front of you. I don't have it in front of me, but the city attorney references it and says that it supersedes the Sunshine Ordinance.
That's not what I asked. What I asked is, what is the law regarding who can obtain a death certificate? That's not in his notes that I can see.
I don't know what the law is around who is able to pay for a death certificate, but it's someone who's related to the person, and I don't know, other than that, if they're unrelated to the person, what they need to provide in order to get access to it.
Is a death certificate considered a public record?
I would say no, not with the person's name on it.
Unlike the master voter file that has every voter's name on it?
I'm not familiar with master voter file.
Master voter file is a public record. Anybody can get access to it, pretty much.
That's one thing our department does not do.
Right. But still, it's public information in a record. Okay, great. Any other questions? All right. How should we dispense with this?
No, I've pulled up the state code here. Let me make sure I have the right number, 102231, is that it?
Well, 102231.
Right. And it, to me, I'm reading, and it describes how this information should be released. It doesn't say anything about who should, I don't see anything where it says who can release it.
Who can release it or who can receive it?
Now, who can release it? The city is saying that they have to go to the state for this information, that the city can't give him this information.
I thought we already had determined that in a previous hearing, that the information was controlled by the state.
What is your question?
In just reading this over, it seems to have the criteria of, death files containing personal identifying may be released to persons expressing a valid scientific interest as determined by, this is part number 5, as determined by the appropriate committee constituted for protection of human subjects, etc. But it doesn't, I don't see anything here where it says that a city who has access to this database can't distribute the information.
Well, there's one section where it explains that the state registrar is the one that's going to prepare and maintain the indices for the information and records for their public release. So my understanding of their argument is that that responsibility of giving the public release of the documents is on the state registrar. And I'm looking in 102230 in section B1.
B1? Mm-hmm. Okay.
They're the ones that prepare and maintain the indices of the birth, death, and non-confidential records for public release. So this whole section is referencing the things that the state registrar is supposed to be doing.
Okay.
So if you read also, this is interesting, 102230 A, number 2, the birth, death, and marriage records indices prepared pursuant to paragraph 1, and all comprehensive birth, death, and marriage record indices prepared or maintained by local registrars and county records shall be kept confidential and shall be exempt from disclosure under the California Public Records Act.
So it sounds like they really want the state to be the entity that is giving out this kind of information or not giving out this kind of information.
Right. DC Price Wolf, do you have anything to add to this conversation? Just maybe in confirmation of what we're coming up with. I mean, is any advice that you can provide us with regards? Are we reading this correctly or anything like that? If you don't have anything, it's fine.
I don't have anything to add. If you have a specific question, I'm happy to address it.
Okay.
But, I think you guys are looking at the right laws and having the right discussion.
Okay.
But I'm happy to answer specific questions along the board.
Thank you. So again, here in 102230 A3, notwithstanding paragraph 2, which I just read, the state registrar at his or her discretion may release comprehensive birth, death, and non-confidential marriage record indices to a government agency. Comprehensive birth record indices released to the county recorder shall be subject to the same restrictions applicable to the confidential portion of a certificate of a live birth as specified in section 102430. Local registrars and county recorders, when requested, shall release their comprehensive birth, death, and marriage record indices to the state registrar. Local registrars may release their comprehensive birth and death record indices to the county recorder within its jurisdiction for the purpose of preparation or maintenance of the indices of the county recorder. The government agency that obtains indices pursuant to this paragraph shall not sell or release the index or a portion of its contents to another person except as necessary for official government business, and shall not post the indices or any portion of the indices on the internet. In B, the state registrar shall prepare and maintain separate non-comprehensive indices of all California birth, death, and non-confidential marriage records for public release. And I don't see anything else that allows any other government agency to do so, local or otherwise. In C5, C1 states that it starts it off, the state registrar shall prepare and maintain separate non-comprehensive indices of all California birth, death, and non-confidential marriage records for purposes of law enforcement or preventing fraud. And in number C5, the birth, death, and non-confidential information shall indices prepared pursuant to this division shall be made available to financial institutions as defined by the United States Code, its representatives or contractors, consumer credit reporting agencies as defined by the California Civil Code, and its representative or contractors, those entities providing information services or purposes for law enforcement, preventing fraud, officers of the court for the sole purpose of verifying a death, and to persons or entities acting on behalf of a law enforcement agency. birth, death, and non-confidential marriage record indices prepared pursuant to this subdivision may be released to a government agency. Have you received anything, any indices, birth, death, non-confidential marriage record indices prepared by the state?
No.
Okay. Okay, members. Any other questions for the respondent? Seeing none, thank you very much. How should we dispense with this?
My feeling at this point is that the complainant would need to go to the state registrar in order to obtain such records. From looking at the code, the Department of Public Health is not allowed to give out this kind of information besides what is permitted to be released to family members to obtain death certificates. So I would make a motion to find no violation of section, I think it's 67.21.
Can you
For
repeat
failing
that
to,
number?
my motion would be to find no violation of 67.21 for failing to respond to public records requests in a timely and/or complete manner.
Second.
Is there an issue of the timeline? Like, it sounds like they aren't legally required to turn it over, but the complaint, is there a timeline complaint as well in here, or is it just not turning over the records?
It's just not turning over the records. It was 67.21 according to the agenda. It says by failing to respond to,
It says in a timely or complete manner.
and those are the exact words that I read.
Oh, okay.
Right, and I'm just verifying that the original complaint was about a complete manner, and there wasn't a not responding in time complaint in there.
Right, my motion is just responding to what is on the agenda.
What's on the agenda is failing to respond in a timely or complete manner.
And/or complete manner, correct.
And I'm trying to verify that they didn't fail to respond within the existing timeline, because it's clear that they have responded completely, but I just want to make sure there isn't a claim of failing to meet dates.
Do you want to ask the complainant?
Sure, we can do it that way.
I'd appreciate the clarification. I think I misunderstood whether you were making a motion on just the timeliness aspect. So we may need to clarify.
So the agenda has this complaint brought under section 67.21 by failing to respond to a public records request in a timely and/or complete manner. And my motion is saying that there is no violation of section 67.21 by failing to respond to a public records request in a timely and/or complete manner. So I'm just trying to be able to completely resolve the item as it's put onto the agenda.
Right, so if we can, before we move forward on the motion, have the complainant come forward.
So, a couple things. First,
It's a pretty much up and down question. Did the Department of Public Health respond within the timeline allotted under the city law to your request?
no, not for all things, because I was asking them data from San Francisco General. They gave me some data earlier on. I asked again, zip on that. There are multiple requests in this particular complaint. One, there had been no response at all from it. They haven't said anything. And by the way, the San Francisco General Hospital is part of the Department of Public Health. They absolutely do record deaths.
Okay,
That's another matter. But I was within this question. I was asking how many people died at the General, at Laguna Honda, and in managed care. I've got nothing from that.
Can you give the dates of when that request was made? I just want to match these
More
up.
than 14 days.
No, the actual date the request was.
I couldn't tell.
All right, I'm just trying to match up dates to see if there is a timeliness violation.
You can look at page 9D6 of the complaints. That might give you some context.
Or 107 is an actual letter from Mr. Roddy.
Well, this is from what he filed. It says, "I'm writing to file a sunshine ordinance complaint against the San Francisco Department of Public Health on August 22nd, 2017, 18 days ago." So
Was that the one that asks Laguna Honda, managed care, and San Francisco General? Because there are two requests for that. One got answered, the second one didn't. So they're in violation of that one. And it was, I filed at the same time I filed to 5 city departments.
Right, so there's...
Which was this year.
On page 107 are your original, copies of your original request dated February 26th to the Department of Health. Okay, the second one was Department of Emergency Management, the third one was Chief Medical Examiner.
That's the right correct date.
They were all on February 26th.
Yeah. That one hasn't been.
Okay, so, but you said that you have two.
Well, because I asked.
So we're talking about this one. Is this one?
This one hasn't been resolved. A previous one.
No, it's not about a resolution. We're talking
or
about.
Responded to or got the data within a timely manner.
Right. Okay.
Yeah, I'm seeing that the November request has a response within the timeline, but I'm not seeing any evidence from DPH in this document of a response, even though it seems like the response would be a redundant response to the previous. I don't see a record of that response.
Right.
The chair, should we ask the respondent whether they responded to that?
Wait a minute. So I just wanted to comment on what Mr. Roddy's assertion was, that because there are deaths in the hospital, the question is whether the hospital maintains a record of those deaths or not. Sorry? Oh, that's the next complaint. Oh, okay. Oh, I'm sorry.
Is that the next item?
That's the next item.
Oh,
Okay.
Right.
So I apologize. So this is for maintaining numbers, indices. But the discussion here is about timeliness right now. And I'm trying to find the thread of emails between you and them. So I got one May 8th. No, that's for Victor.
There's another one on November 29th. It's on page 113 that he sends to
Far down. Yeah, no. Yeah.
It's in the year.
But if you go to page 1615, that's November 14th, 2017, but this is February. Okay, so, all right, so wait a minute. All right, Mr. Roddy, with regards to the records that you provided are the record, so we see on page, starting with page 107, is a letter, a request dated February 26, 2018. And then subsequent to that is a thread of emails that go back to the previous year.
Right.
Okay? How are they applicable to each other?
It is a bit of a rat's nest, I admit.
So let's start with, when did you first make a request?
August last year. Well, actually May of last year, which was, I was just blowing off the hook, go pay $22 a record. August 22nd, 2017, that was when...
Okay, August 22nd. Okay.
And that's when I started. I was asking different ways, and as I got shut down different ways, I'd rephrase it. I should also mention that I did actually get the data from other sources.
But that's not of what, that's not pertaining here. I would say, members, that pages 107, 108, for purposes of this case,
If I can try,
go ahead.
if I
go
may.
ahead. I guess I'm just
Tried to, sorry.
Before you go, I'm just trying to ascertain whether page 107 is applicable to this at all, and whether we should disregard it for this case.
Right. So I was going off of, so looking at the memo from the city attorney's office on page 94 and 95.
Right, that's what I
They
was
lay out the November 14th, which if you go from page 109 onward, you have Mr. Roddy's complaint with this task force filed on November 27th pertaining to his November 14th request, which is, you know, these, the data related to these indices of these death records. And if you follow the subsequent kind of email chains,
Right.
it looks like he received a response on the 16th of November, and then 11 days later, they invoke, slightly incorrectly, the extension for voluminous records, both correct in that it's a 14-day request, and it's also not made the day after the request was made by Mr. Roddy.
Right, okay, so just so there's no confusion, from page 107 to 111, those documents do not apply to this case. They are after the timeline in the following year. And member Kate is correct on page 113 is where this case begins. Member Josh Wolf.
I mean, it seems like there's on page 146 is a request to the Department of Public Health dated February 26th. If the Department of Public Health has not responded to that request, but they acknowledge that they've received it, that sounds like a timeliness violation, even if the request has already been answered by a previous records request.
But the question is the complainant, which period is he referring to? He made one request in November and got some response. So is it timeliness based upon that request and that response, or the subsequent requests that are in writing on the pages that you're noted? They're the same pages that are on 107.
I know.
And so it's the same ones.
He repeated his request, but even if he repeated his request after getting what he got, it still seems like the onus is on the Department of Public Health to respond back that we have no additional records.
Right, but that is not applicable to the complainant's alleged allegation of a violation based upon the first request.
I don't see why not, because that we went through this process with that first request in November with this body. It's the second request that happened in February that actually is the one that is central once you get over the fact that these records aren't available.
All right, now to me that is now conflating the issue, because if you look on page 98 in our legal counsel's report, he starts with November 2017, and then November 16th there is a response, and November 27th there's a further response. And then on November 29th is when the complaint was filed here, and on December 11th, 2017, is the end of that timeline. It does not flow into 2018 at all. This complaint is, from what I can gather, is completely contained in 2017, and further, the date on this memorandum is January 18th. So anything subsequent to that wouldn't be applicable, even if it was included in the record as discovery.
Okay.
So I'm not willing to accept any communications or as being independent of the original case. I think we first have to determine if there's a timeliness issue that you're referring to. Let's focus on that first, starting at the original request. So here, it's November 14, 2017. The complainant sent an email to publicrecords.dph@sfdph.org, making a request, and it's on page, starts on the bottom of page 98. On November 16th, which is 2 days later, and this was not an IDR. This is a standard request. Is that correct, Mr. Roddy? It wasn't an immediate disclosure request?
Oh, yeah, just saying that they received the request, yeah.
No, but did you submit, were you making an immediate disclosure request? Or did you just
a standard.
Standard request? Okay, so then there was no requirement for a next day response. On November 16th, 2 days later, DPH Public Records Officer Veronica Vien emailed the complainant to inform him that his request had been received, but that since it was sent after the close of business hours, on November 27th, which was 10 days later, Ms. Vien emailed Mr. Roddy stating that they are invoking a 14-day extension because of voluminous. So there really isn't a timeliness issue because they invoked the 14-day extension or they invoked a extension within a reasonable amount of time.
But I thought that under the Sunshine Ordinance, you can only invoke a 10-day extension.
You can.
And so there's a timeliness factor that it should have been turned over on December 7th instead of December 11th, because the 14-day invoke extension was 4 days longer than is actually allowed.
That's fine. But there are a couple of different timeliness issues we have to ascertain first. A request was made. Did anybody respond at all? Mm-hmm. If they did respond, when? And if they did respond, did they respond with any records? If they responded with no records but said that we may have some, but we're going to invoke an extension, did they then invoke the extension appropriately?
Right.
Okay, so let's go step by step here on timeliness, okay?
Sure.
Because we have a number of different ways that we determine timeliness, okay? So the first one is, did they respond at all within a reasonable time? I think the answer is yes.
Right.
Okay, so that dispenses with that. The second one is did they then respond within the appropriate time frame after a request was made? So the request was made, original request was made on November 14th. A response was made on November 16th. Which would be because they received it after business hours on November 15th. So let's start the clock on November 16th. 10 days, 26th. Mm-hmm. Okay. They contacted Mr. Roddy on the 27th, stating that they're invoking an extension. Okay. Mm-hmm. That's the timeline we have up until that point. There is some issue there with timeliness. Okay. Now they then invoked the exemption much later than that. They invoked it on December 11th.
No, they gave them the information on December 11th. They invoked the extension on the 27th, which arguably was a day late.
No. They invoked the exemption because of the health and safety code, the reason for not releasing information, which is not a timeliness issue.
Exemption, not a yes. We just
So
misheard.
but the timeliness of providing a response to the initial request in context. So we're talking about, were there records or were there no records? So your request, we have no records that are responsive. That could be one answer. Another answer is, it's voluminous, we need more time. That's another answer. The third answer is, these records are not disclosable because of this or that law. Okay? So the question is when did they respond to that, to either one of those three? Either providing a record, either stating there were no records, or it's protected under
December
law.
11th.
So you have a couple of different timeliness issues. You have one. So I think there's a case to make for timeliness that the extension was extended. Yes, there is a discrepancy in the Good Government Guide on how many days. The Sunshine Ordinance to provide more expediency and transparency has shortened that time from 14 days to 10 days. So there's a 10-day turnaround. The Good Government Guide states it's 14 days, and we have held that to be incorrect for well over a decade. Mm-hmm. And we have ruled on that many, many times. So you have that timeliness issue there. And then further, were any documents then provided thereafter? So it could be multiple violations here. I'll leave it at that. We have a motion on the floor. How should we dispense with that?
I'd like to withdraw the motion.
Okay, is the second agree? Okay, so then we're back to, is there a motion?
I'd like to make a motion for a violation of 6721 for failing to respond in a timely manner.
Is there a second?
Second as to
So
failure
moved
to
by,
response in a timely manner.
okay, so moved by Member Josh Wolf, second by Member Kate. Is there any further discussion? Does everybody understand what we're doing?
Would you like to add a provision that it's failing to respond in a timely manner, but no records are provided pursuant to the state law or something to that effect?
It's up to you guys.
I think we should do that in order to provide clarity as to what our conclusion is. We did find that there wasn't a violation for failure to respond to a request in a complete manner. It's only the timeliness issue, so I think that clarity is needed. But it's up to.
It's fine by me.
Okay, okay, so we'll make that addition. Okay, great. All right, anything else? Can we move to public comment? Public comment on this item. This does not include the parties. Seeing no public comment, please call the roll.
Member Wolf.
Yes.
Member Wolf, aye. Member Kate.
Yes.
Member Kate, aye. Member Kanata.
Aye.
Member Kanata, aye. Member Hood. LaHood.
Aye.
Member LaHood, aye. Member Tesfaye.
Aye.
Member Tesfaye, aye. Member Hensy. Chair Wolf.
Aye.
The motion passes.
Okay. We have is going back to item number.
How about general public comment?
Sorry?
General public
Oh,
comment?
general public comment, I'm sorry. Thank you for reminding me. Please call item number 4.
Item number 4, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction but not on today's agenda.
Is there any general public comment on items not on the agenda? Seeing none? Okay, public comment is closed. Please call the next item. And I just want to warn that after this next item, I'm going to call for a short recess.
Item number 6.
No, item number, well, first let me ask, is Mr. Sakar here?
Yes, I am.
Okay, great. Are you prepared?
Yes, I am.
Okay. And is the Office of Treasurer and Tax Collector here? You are. Okay. Are you prepared? Okay, great. So let's call item number 3.
Item number 3, file number 18001, complaint filed by Julian Sarkar against Jose Cisneros in the Office of the Treasurer and Tax Collector for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and/or complete manner.
Okay, so the matter was heard by the Complaint Committee for the purposes of satisfying the 45-day rule. The item was heard for discovery and collection of information to complete the record on April 27th by the Education Outreach and Training Committee. Are you prepared to provide any background, Member Josh Wolf, on this one?
I don't have any notes in front of me, unfortunately.
I'm going to refer to my notes on this one. Let's see. Okay, so this was a complaint filed by Julian Sarkar. Am I pronouncing that correctly?
That's close
enough. Sarkar, okay. A complaint filed by Julian Sarkar against Jose Cisneros in the Office of the Treasurer. Mr. Sarkar provided who's the petitioner, the complainant, provided a summary of the complaint and requested the committee to find violations. He stated that his initial request for records was mishandled by the treasurer. The respondent provided a summary of the position. They did admit that records were mishandled, but that responsive records were provided. Also, certain records were withheld with regards to confidentiality pursuant to Business and Taxation Code Section 6.22-1, subsection H, and description of the records that have been withheld were provided.
Just as a point of clarification, I believe that it was the request for records that was mishandled and not a finding that any records were mishandled.
Ms. Buckley acknowledged that November 30th, 2017, the letter requesting the records was mishandled. Okay, my mistake. Okay. The committee suggested that the respondent provide a simplified index of records that would not violate confidentiality, listing the number and types of records that have been withheld. The committee requested that the parties work together to come to some determination. There is some possibility records were transmitted wrong address. The committee noted that the task force jurisdiction is limited to the existence and timely disclosure of public records, cannot review operational policies and procedures of departments that are not covered by the administrative code. Okay. All right. Let's start with our regular hearing process. We'll start the clock for 5 minutes. We'll hear from the petitioner first, Mr. Sarkar.
Thank you very much. I think that's a pretty good summary. I would just add that, so this whole matter arises out of a letter that was sent to my home addressing me by my nickname. You're welcome to call me Jules, most people do. But I did think that was a little odd that the Treasurer and Tax Collector sent a letter to my home addressing me by my nickname and threatening me with penalties if I did not register myself as a business, or at least go to the website and complete their checklist, which includes stating that if you work in the city for at least 7 days of the year, that you constitute a business and therefore must be registered. After I did that, I started being told that I have to pay a business tax and that my home address and my phone number would be listed. That's a little bit of additional background. And then I made several records requests with respect to where the information was coming from. And in response to those requests, the only responses I received pretty much constitute the entirety of the responses I received were my own letters that I had sent in, as well as a few emails that showed employees within the Treasurer and Tax Collector's Office sending the letters that I had sent in. Even that initial letter that had been sent to my home, that one had, it was not released. And I would never bother the task force to try to give me a document that I already have, but I'm pointing that out because the privileges that are invoked here, I don't think that they protect that particular document. And so I understand that the Treasurer and Tax Collector has taken the position that these documents, they're protected by both the taxpayer privilege and the official information privilege on the grounds that if they release those documents, it'll make it harder for people to pay their taxes. In this case, I tried contacting the office several times about both my registration, which they eventually submitted, I was not required to do, as well as for the records. And ultimately, they determined that, I guess they didn't determine. What they said in response specifically was, oh, well, if you were never operating a business, then why sign up in the first place, essentially. That's not specifically what the email says. More specifically, it says if you're never operating a business, we can cancel this registration for you, and Mr. Gordon offered to give me some forms to do that, which he eventually did. So it's my understanding that the taxpayer privilege part of this that was invoked, it requires that you have to be subject to that ordinance, and in this case, they've basically agreed that I'm not. If there is someone else's taxpayer privilege invoked, there's no reason that that information can't be redacted, and the rest of that information did not have to be withheld. But in this case, I had not been provided with any identification of any documents. I'd also note that the official information privilege, there's a balancing test as to whether or not there's a public interest. And in this case, I think there's a strong public interest in determining how the Treasurer and Tax Collector selects whom to send these letters threatening with penalties, which, by the way, they're, at least within the letter, not supported by any legal authorities. And I'll also note that during the interim hearing, where this task force determined that, or at least made the recommendation that the records be released, the member Fisher asked the tax collector, well, what about my friend who works at, he's an intern at a law firm, but his pay happens to be reported on a 1099. Does that mean that he's a business? And the tax collector refused to answer that question. It seems to me that, if there's a clear way to read the statute, it would be obvious to everyone. And that's also true of whether or not you can apply this, because if you can't understand what it means to be a taxpayer according to the statute, if the Treasurer and Tax Collector can't explain what it means to be a taxpayer under the statute, it's not applicable. And that goes to the first part, the taxpayer privilege. But with respect to the official information privilege, I note that there's a strong public interest in determining who the Treasurer and Tax Collector chooses to enforce this law against and why. Thank you very much for your time.
Thank you. Any persons or witnesses provide any facts or evidence on behalf of the petitioner, the complainant? Seeing none, respondent? You have 5 minutes.
Good evening, members of the task force.
Hold on one moment, please. Please reset the clock. Thank you. Go ahead.
Good evening, everyone, members of the task force and Mr. Sarkar. Thank you for meeting with us today. As a first matter, I wanted to provide to the task force, now that we have a quorum, the log of documents that were withheld, quote-unquote privilege log. I can give a copy of that now to Victor to distribute and to Mr. Sarkar.
Is that okay?
Since these records were requested, I think we should take them into the record. Usually we like to have these records some days ahead of time. We have a rule on that. Shall we, go ahead.
I feel comfortable taking this right now, but if Mr. Sarkar has any issues with this document or areas of dispute, then I don't think we can take it into consideration, or we would have to hold the item so that he would have time to review and prepare anything that he has to say about the document if he wants to dispute it.
Yes, so with the way this works is when documents are received not in a timely manner before the beginning of the meeting, and they may provide some additional significance or substance that might change the outcome of the case. We give both the prerogative of the task force to either accept them into the record or not by waiving that rule, with the privilege of the other party that was deprived of that information if it would change the nature of their complaint or defense at that time. So, and we would then take that into consideration of whether to accept it or not. The additional alternative to doing that and accepting it into the record, if this will kind of make or break one or the other party's case, is to continue the item if if it's in the best interest of the public. So I'll ask Mr. Sarkar if he feels that if under those provisions, what he thinks. Please come up to the microphone.
Sorry, the question again?
Please come up to the microphone.
Sorry, if I could hear this.
So the question is when we require that documents before the task force, if there are any new documents, be received within 5 days of the hearing date. So it gives all parties time, including the task force members, to review it, and that way make it part of the hearing.
In this case, I did object earlier. I think this is very quick to review for everyone. This has already been continued several times. I think that everyone can read this in less than a minute, so I don't think there's no reason.
And it will not change or change the nature of your complaint or presentation?
It will not. I
heard what
reserve
she
the
has
right
to say about it.
Make the objection to other documents, but I think there's no reason for that with respect to this one.
Okay. So, members, if you're satisfied with that, let's make it formal. Let's take a motion to accept this item, waive the rules, and accept this item into the record.
Move to accept
Can I make one comment? I mean, Mr. Sarkar I understand what he's saying. He hasn't heard what she has to say about this document, so there might be, after we hear from the tax collector's office, he might have a dispute about the document.
Okay.
So we don't know how she's going to use this document against him.
How do you think we should proceed then? Should we hear from
I think we should hear what she has to say about the document and then give him the opportunity to make a decision on this or not. At this point, he doesn't even know what she's going to say.
Okay, is there any objection to that, members? Seeing none? Okay. I'm sorry. Your name again is?
Ms. Buckley? Teresa
Buckley. Okay, great. You're the named in here. Thank you. If you can explain what this document is and how it applies to your defense.
Certainly. So this document is a log, what we might call litigation and privilege log, summarizing the documents that we found to be responsive to Mr. Sarkar's request that we withheld from production on grounds of privilege. Excuse me, not privilege, I'm in another space there. Under the San Francisco Business and Tax Regulations Code, confidentiality provisions for taxpayer information received in confidence, and a tag-along related code under the official information privilege for information received in privilege in the course of our duties as government employees, where the interest in withholding the documents from public disclosure outweighs the interest in public disclosure.
Thank you. So, Mr. Sarkar, does that change your perspective on this at all?
No, I withdraw the objection solely as to this document.
Okay, great. Okay, now, so we have a motion. Are you satisfied, Member Tesfaye?
Yes,
Okay, great.
thank you.
So we have a motion by Member Kate, seconded by
Second.
Member LaHood, Is there any public comment other than the parties? Seeing no public comment, can we take this by acclamation? Is there any objection to taking it by acclamation? Seeing none, no objection, the item is approved. Okay, so this record is now part of the case file. And now we'll hear from, if you start the clock again, 5 minutes. We'll hear from Ms. Puckley's testimony. There we go.
Okay. Good evening, everyone. My name is Teresa Buckley. I'm the custodian of records at the Treasurer and Tax Collector's Office. I'm also the tax collector attorney. I want to begin my presentation with a short overview of our office so that people here who don't work in our office have an understanding of what we do. So our office, Treasurer and Tax Collector, is referred to as TTX, so I may use that for shorthand. It has two main sections. The Treasurer's Office manages banking, accounting, and other county treasury functions. The other primary section is the Tax Collector. This is the part of the office that was involved in the issues leading to this Public Records Act request and Sunshine complaint. There are several parts of this tax collector office: property tax, business tax, the legal section, which I oversee, the Bureau of Delinquent Revenue, and that's the section that pursues bills that are past due, delinquent. These divisions work somewhat independently of each other. Our office is a quite busy one. We received approximately 1.2 million pieces of mail last year. We registered approximately 15,000 new businesses and have approximately 120,000 registered businesses altogether. The vast majority of businesses register online, not in person. The office collects several $1 billion in taxes annually, most of which comes from property tax, the payroll expense tax, the gross receipts tax, and the transient occupancy tax. It is important to keep in mind these separate functions and purposes that the various parts of the department are working on when we go into Mr. Sarkar's request. But first I want to begin by acknowledging once again that we understand that we mishandled the original request for records. We have never disputed that. We have taken steps since that time to train and sometimes retrain staff on what a Public Records Act request looks like under the California Public Records Act and the local San Francisco Sunshine Ordinance. I have personally led those trainings, and it is my goal to roll out the training for every single employee in our department, and we are over halfway there. So we do take this very seriously, and we apologize for the delay. The remainder of our position was described in our filings before the board. Previously, the Sunshine Task Force, Once we uncovered the initial request on December 28th, I took immediate steps to uncover responsive records, to acknowledge the delay and apologize for it, and to proceed with responding as appropriate. Turning to the Records Act request itself, Mr. Sarkar requested information regarding why he was sent what we would call a soft letter in October of 2017. The basis for that, the information that he requested, we received confidentially from a taxpayer. It was a result of a taxpayer provided that information to our office in confidence. As a result, we could not disclose that actual document to Mr. Sarkar, and we responded in a letter explaining the basis for that, which was that it was confidential under section 6.22-1. Quote, information in the taxpayer's return is confidential response or from the taxpayer themselves or in response to an investigation of a particular taxpayer, including the fact that the tax collector has sent a request for information to a particular taxpayer or is investigating a particular taxpayer. We also invoke the official information privilege, finding that the information that we've received in confidence should be kept confidential under the public interest.
How much more do you have?
I mean, that's the gist of it, and it was all described in my papers previously.
Thank you. Are there any persons or witnesses that provide any facts or evidence on behalf of the respondent? Seeing none, members? Member Josh Wolf.
I have a question for the respondent.
Ms. Buckley.
So we have essentially a record of an email and a spreadsheet on this page that you've explained why you're not, why that you feel that that is not a disclosable document. Was the email, first off, was the person who sent that email compensated for providing that information?
I don't believe so.
Okay. And then secondly, was the information provided unsolicited? The exception that you cited spoke of an investigation, and in my understanding of an investigation, you have to decide that you've opened an investigation. So an unsolicited piece of email containing a spreadsheet of information would not proactively create the investigation. So I'm trying to figure out whether you invoked an investigation and this spreadsheet came out as the fruit of that investigation, or whether this spreadsheet and email came to the tax collector unsolicited.
Okay, so I can't go into the particulars of why the email was sent to my predecessor, Stephanie Prophet, but I can say that in general, it's known around the city and county of San Francisco that our office actively pursues information in order to ensure full compliance with the business tax laws in the city. And through that process, you've probably heard in the news that we have on occasion gone after certain businesses to get information to ensure compliance, sometimes within that business and sometimes related participants doing business with that company. I can't go into the specifics of how this particular email came to us, but it is part of our broader effort to ensure compliance with the tax laws that this email came to our office.
Great, thank you.
I have a question for you, Ms. Buckley. Is this case still under investigation, still open?
So I should clarify that the provision that we use as the basis for withholding the records of confidentiality, the primary one is in our local ordinance. It's an investigation or information we receive from a taxpayer, and I think it would be mischaracterization to say it was an investigation. It was part of the broader effort of finding information in order to ensure compliance with our tax laws. So I would say it's more broadly in the general purpose of what we do in the department.
So how would you characterize if you receive in general, you receive a complaint? Is it considered a whistleblower complaint? How's it considered?
If just stating hypothetically, not this particular instance, I just want to clarify.
Well, I mean, how is this? How would a report from a member of the public like this against another member of the public or an entity of the public? How does a tax collector? This would be under the tax collector, right? Not under the treasurer's section. So under the tax collector, how would the tax collector regard that? Like, for instance, if it was under the police department, and it'd probably go to the detective unit, and it'd go under investigations, that kind of thing. And so the burglary unit may not be involved at all. So here it's the tax collector unit, okay? So here, when you receive a complaint, what's the process and the procedures, and where does confidentiality begin to apply?
Okay, so just a point of clarification, I wouldn't necessarily categorize this as a complaint. It's information we received in our office as part of our efforts. I wouldn't characterize it as a complaint. I'm not comfortable.
So then classify, how do you classify a communication from the public in general that's received to your office?
So I would say this is a taxpayer communication.
Okay. And how are those, let me just ask one more question. And so then when you receive any taxpayer communication, how do you classify them? Under what status are they, or what do you do with it?
Okay, so if my office receives a taxpayer communication, and this did come into the legal section, we will coordinate with the various different sections of the tax collector division of TTX. As I stated, we have a Bureau of Delinquent Revenue. Sometimes it would be in relation to that. Sometimes I receive taxpayer communications regarding old delinquent debts. Sometimes it is stuff that isn't as old, is more of an ongoing matter that would be in the realm of our business tax.
Okay, so we get the gist of that, but then how do you apply it as far as whether this is a protected communication or not?
Fair enough. So in general, information we receive from taxpayers, or even information we send to taxpayers that is about their specific tax status, we treat as confidential.
And is there a law that guides you for that?
Yes, the San Francisco Business and Tax Regulations Code, section 6.22-1.
Okay, I'm going to stop there. Member LaHood.
Question through the chair. Because we don't know whether this was solicited or not solicited, and I think there maybe are some assumptions that somebody decided on their own to send it in, but is it possible that we're talking about something where a taxpayer was asked for information about their own business, and because of that disclosed interactions with contractors or subcontractors that then led to this being pursued? I don't know if that's relevant or not, but when I'm...
Well, do you think it's relevant? If you think it's relevant, let's ask.
Is hypothetically, whether this case specifically or not, sometimes does information come to your office because of questions asked to one taxpayer reveal information about other taxpayers that may cause you to decide to query those secondary and tertiary businesses?
Well, I will say that it's well known that our office, in conjunction with the city attorney's office, pursued information from Uber about Uber drivers who were operating in San Francisco. So, that was something that made the press, and there were several articles about that. And we have at other times pursued. There was a case that was recently at the California Court of Appeal with HomeAway, which is kind of like Airbnb but different somehow. And we also, our office, tried to get information from that company, and it was in the press. So yes, we sometimes take tactics like that to cast a broad net. I can't go into specifics about what happened here, but those are things that our office has done to collect information.
So let's just ask, without you providing any specific details, were those tactics used for this particular situation, this particular case?
I can't go into the specific circumstances.
So what under what code of law or what citation law protects you that information, the actual tactic of how this information arrived to you? Can you tell us how this information, this taxpayer communication, how, that's what Member LaHood is asking. How did it arrive to you? Was it solicited by the tax collector along with the city attorney? with or without the city attorney, or did it just happenstance show up on your door? I think you can answer that question.
It was definitely, I'll say that it's something our office initiated, and the information about was in response to that, but I can't say any more than that.
Okay, that's fine. Is there anything else you
No,
want to
that
add?
actually, that was helpful. Thank you.
Anybody else? Okay, so I would just, I have a couple other questions. So again, is this particular incident or issue, is this still still active? And the reason why I ask is because, if you're going to claim that there's some level of confidentiality, and if there is some, let's not call it investigation, but some procedure that is still active, and you have some rules around active procedures, and sometimes, items that are a case that are in it cannot be revealed, much like in a police investigation case or any other kind of case, a whistleblower case or what have you. But until those cases are closed, those incidents are closed, and the cases, they can be then released to the public for public consumption. So that's why I'm asking if this is still open or not.
I'll say that in general, there is still this effort that led to this particular information is still ongoing.
Okay, good. Okay, so of the code that you cite, does that prohibit a person from their own records?
So I would say no. Their own records that are, for example, information, if you're running a business in San Francisco, your own tax filing with my office, you would be allowed to see. You submitted it. If you asked, we do have protocols in place before we would release your own taxpayer information to verify that you are in fact the person who either is, say, you're a sole proprietor, that you really are that person, or you are an accountant or a lawyer or someone with authorization to look at it. Otherwise, we hold this information strictly confidential.
What about information of complaints or other tertiary information that might be applicable, some association with some other action of some sort? Are those available to a person that's contained in their record?
So I'll say in general, it is pretty rare that our office, as a treasurer and tax collector, would be fielding complaints about a business. It could be in a related function that might go to, say, the city attorney's office and the code enforcement division, or perhaps one of the various departments that we work with to provide licenses. But the complaints themselves, it's just not really a function that comes to us. We collect the taxes, we issue business registration, we maintain a database on Data SF, and basic information is provided there, but we're not really a complaint fielding organization.
Okay, so this is going to be a little more difficult question. How can we know, this body here, how can we know that the information that you're withholding is in fact applicable under this business and tax code section that you're citing?
Well, that's a good question, right? Because I provided the basic parameters of how the information came to our office. There are indicia that I think should lead you to, that I think leans toward credibility. What we're saying, this was an email received by the tax collector attorney, Stephanie Profit. She was my predecessor in this job. This email came at the time she was the tax collector attorney, and it was received on her work email. And it's telling you it's a third-party spreadsheet. You can also, we're going on the record here saying that these are the records we are withholding under the confidentiality provisions that we believe apply here. And then in turn, our office communicated with Mr. Sarkar a year ago information. And he's gone on the record saying that he received a communication from our office. So, the pieces point to it's pretty clearly tied in time. It's not that close in time, but it is a record from our office. It's an email. I reviewed it personally, and I helped prepare the documents. And as a custodian of records, I take it pretty seriously. I'm not just.
Yeah, I hear you. That's enough. I understand what you're saying. I just because we're not a body that can subpoena records. We don't hold people under oath. We can compel the production to some extent if we can find that the reason for them being withheld is incorrect. But we also have to know what the record is, without the record being produced so we can see it, even in camera. How are we to know whether the taxpayer communication falls under a certain litmus that the law provides? There are those kinds of questions that we have, and it's still kind of a question of where do we send it to if we think that that's a compelling question. Can our legal counsel see it? To help us determine yes or no, this is applicable or not applicable. Okay, there's that question. Considering that we have an ethical firewall between us and the city attorney, it's not appropriate for us to send it to the city attorney, considering they work directly with you in helping you to make those determinations. Yes or no?
I believe that there is an ethical wall between your counsel from the city attorney and counsel that we would consult on matters, but he might speak better to that than I would, but it's my understanding that there is one.
Well, if you can provide information on the procedures or how things are applied by the city attorney as part of providing us just with information about how a department works, that's one thing. But as far as being able to see an item in camera, that would be independent of the city attorney. We wouldn't ask the city attorney for that unless they have no connection to this case or to you in general. So it'd be that kind of thing. Member Josh Wolf.
I don't really see how either our city attorney representative or even the task force can review this document in camera and make an effective determination.
On what basis?
On that, if it came before if we somehow created a way for the task force itself to review it in camera, I think that creates a bizarre conflict of the task force seeing documents. Maybe it's okay, but it creates a weird disjunct in how to actually execute it is tricky. If we have our city attorney representative look at it, that stuff's a little less tricky, but what exactly can he tell us? I'm not sure what the questions that we're hoping to get the answers through the city attorney.
Well, my question is pretty clear. Is the document, they're stating that they have a certain procedure or a certain litmus that would allow withholding of the document based upon a certain section of law. How do we know that what's contained in that document is applicable to that litmus? If I think we can trust our legal counsel to make a fine determination of that and to let us know that they're applying it correctly or they're applying it incorrectly. If they're applying it incorrectly, then we have a different line of questions. If they are applying it correctly, then it sends the case in a different direction. I think that we struggle with that all the time when there's a citation for withholding of records, whether they're actually fully withheld or whether they are redacted. The information on it's redacted. In the cases of a police investigation, it's a little more clear cut. Okay, because either a case is open or it's not, and it could be proven. There's records to show whether a case is still open or not. The question here is they're testifying that they don't conduct investigations in this way. They're just protecting a single document, a taxpayer communication. And they're also citing it that they're doing it in the best interest of the public. Well, we have the same charge to whether documents are to be revealed that are public information in the best interests of the public.
I mean, I think we can trust for the most part that the two documents are what this spreadsheet and the testimony has alleged. I think the questions that you're putting forward can be addressed without actually obtaining the content referenced in this referenced by the spreadsheet in the email.
How? I don't understand how. If I don't see the document or know what's in it, how am I to know that what they're saying that it should be protected for the reasons that this law provides is appropriate?
I mean, in essence, what we can construct theoretically based on this document and the testimony is that there's an email that says these people may have businesses. We don't know the context as to why. And here's a spreadsheet with a list of names, including Julian's name is Jules, which, may allow Julian to identify where he wrote his name down that way. And this email may help Julian to determine, where they got his information. But I think that in terms of whether or not it rises to a protected document or not, I think we have all the facts we need to make that determination. I don't think actually knowing the details is going to help us here.
Well, I'm not convinced that the document itself, without knowing what's in it, is a protected document.
I'm not convinced it's a protected document either. I'm just saying that I trust that what we've heard described for the document is legitimate, and I think we can make the determination whether it's a protected document based on the assumption that what was said in this context was accurate, because there's no reason to distort it. Now, there's questions that we didn't get answers to, like whether or not this spreadsheet came unsolicited, and I think that has a significant bearing on whether or not it is protected under 622(1). But I don't know whether actually allowing our city attorney to review the document in camera would in any way provide us substantive information to make a more legitimate finding.
Okay, I guess my thinking on this is if the document isn't what the tax collector determines it is, and they're applying the Business Tax Regulations Code 6.22-1 incorrectly, then the document can be deemed public.
I agree. I just am saying that I think we can make that determination without seeing the document, just based on what the description of the document is that's been put forward.
Okay. I'll let you make that argument. Absolutely. I'd like to hear that argument.
You just did it.
Go ahead.
I thought you just made that argument right now.
Then I'm not following the context.
I mean, the only thing I want to say is that throughout the hearings that we have here, we are presented with facts that include confidential documents that we have not been able to actually see. We've only been given a description of what they are. And I don't know why we would treat this case any differently. Here we've been given a description of what the documents are. We know it's a spreadsheet that contains Mr. Sarkar's name. In the context of an individual who may be running a business in the city of San Francisco without being registered, I don't see how that's any different from any other documents that we have been faced with here that have been called confidential, that we have not actually seen the document, and we've relied on the description of the document and the designation of it as confidential. So I'm wondering why we would treat this case differently, why we would see this, why we would actually view this document in camera when we've never done that for other documents that have been deemed confidential. We've relied on the description.
I mean, I'm still concerned about the fact that we don't have the information about how this document came about as an email. Like, if this document was unsolicited, I think that totally blows a hole in the 6.221 defense, but we don't have an answer to that question.
We did. That's what
I asked about. It was not unsolicited. It was part of an investigation.
Or like, not an investigation, or an open inquiry kind
open
of thing.
inquiries. It was, yeah. It's not that your neighbor who doesn't like you sent it in.
Right, but we don't know what prompted the open inquiry. Like, we
Right.
can't draw
We don't
this
know.
line. Like, an open inquiry could be like they put. I mean, they literally have said things in articles that, like, they're looking for people that have businesses. So, like, that could be the catalyzing. Like, we don't have the narrative of how this document landed in their box. We have a bunch of generalities, in my opinion.
Yeah, I as far as the comments around other cases that we received around this, other cases have been a little more specific because the documents are specifically described, and the law makes it clear the description of those particular documents. I'm not so sure it's the same in this case, that a document that's received either solicited or unsolicited by a department that is, has this particular area of law is more about disclosures of the person who is being taxed, not people that are necessarily providing other information about a person who is being taxed. So, like your file as a business is held, some of that information is held in confidence. But communications that are provided about you with regards to your case, I'm not quite sure that that is.
That's my read as well. My only contention is that I think we can make that determination without seeing the document.
Okay.
And so in this case, would you be talking about the email, more so the email than the spreadsheet? Because I'm guessing, I mean, from what we've heard, the spreadsheet would be like a list of names of people who may be operating a business that have not registered with the city. And I can see where the code would protect those names of people who may or may, we don't know if they are paying or not paying or have a business or not a business.
Right.
But it seems like more of your concern would be about the email that the spreadsheet was attached to.
Well, I guess let's ask, Ms. Buckley, are both these items one and the same?
Yeah, it was an email.
With an attachment?
The date.
Yeah. Okay, yeah, but there's no other information, so it could be independent headers, yeah.
Does
Deborah LaHood.
it matter to us how many individuals or businesses are identified in this spreadsheet without knowing who they are, but number-wise? Does it matter to us if this is a small number or a large number, or is that significant or insignificant?
I mean, I think if the number was only one,
Then
Mr.
it would be
Sarkar,
significant,
then he wants the document, and if he's the only person listed. But if it's a bunch of other people who may have some kind of issue going on with their taxes or business license, then I would have a concern about their privacy as a potential taxpayer.
So I think.
Oh,
I'm sorry. Go.
But if it was only his name, I would have less of a concern because he wants the document, and if he's the only person.
But there's redaction. He could provide the whole document redacted except for what applies to him.
Well,
Can we ask about that?
Sure. Ms. Buckley?
I was going to say that there's another piece here that I didn't get to because I ran out of time, but just in weighing the balancing of factors for the Evidence Code 1040 official information is the public interest in maintaining the confidentiality of this document is a bit broader. It's not about me doing my job. I'll do my job however I have to. I'll get by. But the purpose of our office, the tax collector, is to collect money so San Francisco can function, so to make sure people are in compliance, so we have money to pay for that police siren outside, to clean the dirty streets outside, fire department, you name it. So it's a broader concept of if this is disclosed, then we have concerns that our ability to get information down the road will be compromised and people will be less willing to cooperate with us if they know that that's all going to be out there. We rely on people. It is the law. They're supposed to comply with it. need help, and we don't want to discourage compliance with it, and this is one of the tools in our toolkit. And the balancing of the public interest in disclosure is somewhat limited. I don't know that the whole public needs to know why Mr. Sarkar's name is on this list. I don't know that he wants everyone to know. I don't know that. But
Well,
we're doing this for a bigger purpose than just my specific.
Right. I mean, in the spirit of personal privacy, totally understand that. But at the same time, public records are public records, until they aren't. So we have to. That's our job, is try to determine where it begins and ends at that point. I just want to go back for one brief moment in section 6.22-1A. It speaks very clearly about investigation. Okay, it states the information. Information regarding the tax collector's investigation of a particular taxpayer, including the fact that the tax collector has sent a request for information to a particular taxpayer or is investigating a particular taxpayer, is also confidential. Is this an investigation?
I can't comment on whether this was the result of an investigation of a specific taxpayer. That would be confidential.
Through the chair.
Yeah, Member Josh Wolf, I'm sorry.
So this body has found that every document is a public record, even if none of the information on the document is public. I don't see anything in our city law that says that either this email nor the spreadsheet are explicitly excluded from being public documents. In the case of the email, it may be that only the A's, us, thus, etc. are what isn't redacted, but I don't see a reason that some portion of that email isn't a public record. Like I said, even if it's just A's, ofs, and thus. When it comes to the spreadsheet, I again can't see a reason the entire spreadsheet is redacted, even if every name on the spreadsheet is redacted for privacy information. The columns of what each of the headers is, I don't see a reason that would be redacted. And the number of lines of how many people are listed, I don't see a reason that could be redacted or should be redacted. I believe that there's information in these documents that is public information, and that the tax collector is obligated under the Sunshine Ordinance to turn over a redacted version of these two documents. And then if the complainant still feels that there's information that shouldn't be redacted, it is worthy of bringing back to this body. But I can't see an argument why neither of these documents isn't provided to the complainant in a redacted form.
Okay, so one, separate the documents. Which document is public, which one isn't? Second, does the law allow for the withholding of the document, or that the information on the document is held confidential? The difference being, if it was, say, a law enforcement investigation, the whole case file cannot be released, not one piece of information from it, until the case is closed, maybe under certain conditions. But that's how lots of times things have been held and presented with us. If there's something's under investigation, unless it's already been released, like as part of discovery, to parties within a court case or something. But then there are other instances where the information on the page itself can be held in confidence. For instance, personal addresses, social security numbers, things like that, phone numbers, or what have you, but not the other parts. So I think that's what you're referring to here.
I mean, essentially, I think that there is a spreadsheet. In this, under 622.1, it's only talking about the actual information being confidential. It in no way creates a confidential document class the way we have with the police. And so I don't see any reason that these two documents on this sheet don't need to be provided to the complainant in some sort of redacted form.
Okay, so I'm going to stop you there. I'm going to ask DCA Price Wolf what if you can provide some clarification on that with regards to, there are some documents that could be withheld completely, the whole physical piece of paper or bytes of information versus the information itself that's on that medium. And so in this case, we're trying to ascertain for either or both of these items that are on this list, email and spreadsheet, are they, and based upon the law that the tax collector is citing, can we compel them to provide the documents redacted? Let's have you have this on the record, if you don't mind.
So there's a lot there to unpackage. Are you asking me whether the Sunshine Committee can ask Ms. Buckley to provide you with a redacted document?
We already have the ability to compel the production of public documents. Mm-hmm. What we're asking for is according to the law, it's somewhat of we want some confirmation of what we think this may apply, that in section 6.22-1A, it talks about the information. It doesn't talk about the document, the actual medium, the piece of paper. It talks about the information. And we usually hold that to be that information on a piece of paper is to be redacted versus that records are to be withheld, which is a different classification. That's not redaction. That is the physical records cannot be released. So that we're trying to determine, based upon Member Josh Wolf's interpretation, that one or the other of these documents are that they can be produced, and they can be redacted.
One or both.
One, well, either or both. Either or both.
So again, you said a lot of things.
Okay,
there.
so
are you asking? Are you allowed to get the records so you can make a review on your own? Are you? I'm not
no,
really sure.
We're asking first of all if the records can be withheld altogether.
Yes.
Okay. Versus can the records be released but redacted?
Yes. They both can. If a record can be released in a redacted form, meaning it has some confidential information but not all, like the agency can choose to do that. That's my reading of the disclosure laws. But if redacting it to such an extent would make it meaningless, then there's no sense in providing a fully redacted document, so it would be withheld.
Go ahead. So I guess the thing is even if it was redacted in whole, the production of a document at all shows that it exists, versus saying that it doesn't, because we don't know if it exists or not. I mean, we can trust that I will say I trust they exist, okay? The point is whether the physical document can or cannot be released. For instance, in a whistleblower case, cannot be released. It's all sits somewhere in a very highly protected area. Okay, so none of that, not the record nor the information in the record can be released. Here we're asking, based upon the law and the way it's written, can the document be released but not the information that's on the document? And I think that's what we're getting, the crux we're getting down to.
Yeah, and I think there is value in fully redacted documents. If you're trying to find out how big a report is and the entire report is secretive, but you have one blacked out page versus 300, then you know how long the report is. And I think that information does carry merit.
Okay. So that's what we're trying to get. We're trying to get some advice on.
Right. And so, I mean, if I can just take a step back,
Yep.
It seems like what the agency is trying to do, what the task force is trying to do, is ensure that particular city agencies are correctly redacting and withholding documents according to whatever privileges they say they have.
Right.
And it also sounds like the task force is struggling with the fact that they have not been able to directly review these documents to ensure that the exemptions are properly applied. Is that fair?
That's fair.
And I appreciate that, and I think so does the agency, but I actually think that's where it ends. Because I don't think that the law allows the task force to review the documents to ensure that it's correctly applied. I don't think this is the correct setting in the task force agency to make sure that the exemptions are correctly applied. I do understand that seeing certain exemptions might be helpful. For instance, as task member Wolf said, if one page is redacted versus 100, but I just don't think there's a mechanism in this setting for the task force members to review documents and determine whether the exemptions were properly applied.
I get that, but there is also a case of if there was a form, if there's a standard form that the city uses, the form itself is not confidential. The information that's on the form is confidential, so you can redact the information on the form. But the form itself is still releasable because there's other information on it that is publicly available. Okay, and so what Member Wolf is trying to ascertain is whether information that does not reveal any confidential information can be released to the public. Maybe that's a better question to ask Ms. Buckley. Let's ask Ms. Buckley that. Is there any information of the documents that are released here? Is there any information that can be redacted and then provided? Because frankly, any information that's received by the city is public information, belongs to the people, unless otherwise, right? Right, unless exemption applies, right, for exclusion. And
Yes. I'm more comfortable typing on the email than the spreadsheet.
so take them one at a time. Go ahead.
Well, for the email, in order to, you could redact it, but it would redact, the only stuff you would see is the date, the spreadsheet .xls would probably have to redact the name of the spreadsheet and the recipient. I mean, the recipient is my predecessor, Stephanie Prophet, but the sender, we have to redact. And probably the message and the signature line. So you'll get maybe more to your satisfaction indicia that an email was sent, but, you know, I wouldn't present it here in this form if it didn't exist. I wouldn't do that. But it would be so redacted. I mean, I guess it gives you comfort to see the kind of blacked out Outlook inbox thing. It would be very heavily redacted.
That's fine. I think what is, if I had to go to court and I had a document that showed that this was received in your department, and then your department doesn't really present that discovery, but I was as the complainant, I say, but I have a document. They sent me a document. Even though it's redacted, it exists. So please make them produce it. Okay? It's another thing to say, I know they have that document, and then the other party says, no, we don't have that document, and then it becomes a very messy situation. So I think there's comfort for both parties that if you have the document and the other party doesn't have the document, but here you're saying that it does exist, anything that's provided to the other party, redacted in total or not or partial, I think is in the best interest of the public, because it's a public document.
I appreciate what you're saying. As a former full-time litigator, it would be often not going too far to withhold the document. So it's you could do it either way, as your deputy city attorney says. We elected to do that because there's very little that could be disclosed here. I
Okay.
believe what could be disclosed is that Stephanie Prophet, everything in the law pretty much is what you would get.
Okay, thank you very much.
I just wanted to add one more thing.
Sure.
My interpretation of what is required under the Sunshine Laws is not even this. This is what is called a privilege log, is that I think Ms. Buckley went above and beyond by providing this to give the committee a little more information, but simply her letter, which referenced the reasons that some documents were being withheld, is what's required under the law. So that's my interpretation. I get the sense that Chair Wolf disagrees, but that's my interpretation.
It's not that I necessarily disagree. I would agree, provided that we are able to get a little more confirmation of whether the information is what it is. That's the thing that we struggle with here, because any respondent can show up and cite any section of the law and say this document is that. How are we to know? Okay, that's just for the purposes of transparency, for why we are here. That is why I think it's important there should be some process so that we have some ability to know for sure whether we just get confirmation from somebody who can see it in confidence in camera to be able to do that or not. Maybe this isn't the right venue then. Okay, that's what it really comes down to, right? Member Josh Wolf, and then I want to proceed to try and dispense with this case.
I still think that compelling the tax collector to provide these two documents in whatever redacted form they determine is appropriate is the valid next step, because it empowers the complainant with the actual documents in hand. There may be nothing more beyond what's in this this outline, but it provides the actual exhibits that, should he choose to move forward, whether through this venue or through a court venue or whatever venue he's seeking, there's the actual physical documents that I have not heard a good argument, other than everything on them would be redacted, to not turn over.
I have a
Anybody
question.
else? Go ahead. Testify.
So to that point, we have both a communication from the tax collector's office as well as this privilege log where they are agreeing that these two documents exist. So I don't see what would be the difference between the petitioner having a fully redacted copy of two pieces of paper versus having a letter that was signed by Ms. Buckley saying that these two documents exist and we can't give them to you for these reasons, as well as this document that's now in our record, the privilege log, that also states the existence of these documents.
I mean, the primary reason is the spreadsheet, which the respondent didn't really go into how they would handle that. But it is my belief that the number of cells and the number of columns is not in any way protected information, although it may not be of benefit to the complainant. I think it's public information that he has thus far been denied.
Well, I may disagree with you on that, because if this is an original document that was provided by a member of the public and not a city official document that would be a standard document, public document, then I can see that there may be some information in one of those headers of a column or a row that might reveal.
No, I think that there may be information in those headers that is redacted. What I'm saying is, I don't think the number of rows and the number of columns.
Oh, I see what you're saying.
Is protected
Your
information.
argument is the quantity of public value.
I don't know what our complainant is looking for, but I do know that, the number of columns and the number of cells in the document has some level of evidentiary value that I don't feel is protected.
Okay, great. Anybody else have any other comments on this? Okay. All right, so should we move to rebuttals? Okay, great. Ms. Buckley, you begin rebuttals. You have 3 minutes.
So I think I have covered everything pretty much through your question. We believe these records are confidential. They're taxpayer records received from a taxpayer, and we treat them as confidential. We believe that's in the best interest of the city and county of San Francisco to perform our functions, to collect money and help fund the city government. And we are happy to answer any further questions here, but I think we've covered everything exhaustively.
Is that it? Okay, great. Mr. Sarkar, you have 3 minutes.
Thank you. So I'd like to say first, with respect to the public interest, the balancing factors, I do think it's important for the the treasurer and tax collector to be able to do their job, and as well as pay for nice things like the Sunshine Ordinance Task Force. But on the other hand, during the interim hearing, I know that the task force said that it has to abstain from, for example, making the determination as to how a statute should be read with respect to the definition of a business or a taxpayer. But that's also, I think that's a part of the inherent problem here. If we release these records, for example, it might have, it very well might have the effect that the tax collector is saying, which is that people will be they'll be reluctant to, for example, do business with someone that's giving information to the tax collector. But at the same time, how many people out there receive these letters and just said, okay, well, the government's telling me to do this, I need to sign up, and now their home addresses are out there on the San Francisco, a database of registered businesses. So I do think there is a stronger public interest in revealing these records. One of the cases that I cite in my brief was against the State University of Fresno, and in that case, they said that there was an official information privilege because they didn't want to disclose information about donors who had purchased, I can't remember quite exactly what they had gotten in exchange for their donations, but. And I think that they were correct, that information being released, that would make people hesitant, to donate. But if there's problems in the system, like there was in that case, and I think that there is here, there's a stronger public interest in releasing the information so people understand how the system works and can go to the Board of Supervisors and say, I don't think it's accurate to say that working in the city for 7 days turns someone into a business unless somebody gives them, an employee status. And so that's what I would say is, the prevailing basis for the public interest factors and why this information should be released. Thank you.
Members, any other questions? Hey, Mr. Sarkar, I have a question for you. That's all right. To your knowledge, do you know that based upon this particular incident, has your information been released publicly?
Well, incidentally, as a result of my starting this complaint, yes. But
no, but I'm saying prior to the filing of the complaint, had it?
I'm sorry, I don't understand what you mean by released publicly, and which information about me are.
So you're saying that you, in your rebuttal, you stated that it's in the public's interest that people's information not be published.
Right.
So
I did not get to the stage where, as a registered business, my home address, for example, would be listed. Had I, completed the process without further inquiry, I understand that would have been the case.
So to your knowledge, your home address is still protected, other than what you have released on your voluntary release?
Yes.
Okay, great. And Ms. Buckley, you can confirm that?
Yes, that's correct. If he never fully became a registered business and, went down that path, it would never be on the Data SF website. And I'll add that people can elect to list their address in different ways through P.O. Box. If they don't want to have their home address on there, we allow for that. So we have means that we work with taxpayers to do that.
Yeah, I guess the question is more about, in this particular case, was his information made publicized or published anywhere? Or is it still being held in confidence?
It's still being held in confidence.
Okay, great. Thank you. Okay, members, how should we dispense? Yes.
So
Member
this
Joshua.
is not exactly within the purview of this body, but I think the complainant brought up something that in some way interjects this, which is that everyone, unless they went through the trouble of creating a post office box or had the forethought to realize this, that, drives for Uber, runs Airbnb, etc., that their address is publicly listed around this issue that they're saying that we're protecting all this other stuff, and then simultaneously everyone who has a business running out of their house either has to get a post office box or their personal address is publicly listed. Like, there's some weird competing philosophies going on here. And again, I don't think that those addresses being publicly listed is necessarily within our confines, but it jumped out at me.
Yeah. Okay, how should we dispense with this? Is there a motion? We need a motion one way or another.
Well, both parties seem to agree that there was a mishandling of the original request. So a time issue. And I agree with Member Josh Wolf that we should ask that a redacted form of both the email and the spreadsheet be produced, because I do think there is some benefit in knowing if the spreadsheet was 1 column, 1 row, or 1,000 columns, 1,000 rows. And it is public information.
I'll second that.
So is that a motion?
I was opening it for discussion.
I'm sorry, I thought you made a motion there.
Yeah.
Okay, member testify.
So to open that to discussion, if that comes before us as a motion, I would prefer it be 2 separate motions. Just putting that out there.
Oh, that's fine. So let's have a motion for violation of 67, well, was it an IDR or not? 6721 or 6725? I don't remember the...
6725 is IDR.
Right, no, but
6721
was
is
this
not.
one an IDR that one? And no, it wasn't. So then, violation of 6721 for not providing information in a timely fashion?
I'll second that.
For not responding in a timely fashion.
Correct.
We call that timeliness. Okay, so it's moved by Member Kanata, second by Member Josh Wolf. Any other deliberation on that? Public comment, not parties, other than parties. Any other public comment? Seeing no public comment, are we ready for a vote? Please call the roll.
Aye.
Member Wolf, aye. Member Kate?
Aye.
Member Kate, aye. Member Kanata?
Aye.
Member Kanata, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member Hinsey? Member Hinsey, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
Okay, is there another
Well,
motion?
well, why don't we discuss the issue of asking the department to produce redacted documents? I know.
I don't have anything to discuss. I just wanted the motions to be separate.
Fine, and then I do have a motion to ask the department to produce a redacted version of both the email and the spreadsheet.
And I'll second that again.
Wait, sorry, I thought the motion would be on a violation or not a violation of something.
He's asking to compel
Okay.
under 6721.
So are you saying, okay, so under 6721, is your motion saying that they failed to respond to a public records request in a complete manner?
No, it's to compel, right? Mm-hmm. It's not about a violation. It's compelling them to provide these public documents.
Pursuant to what requirement?
Pursuant to 6721.
Because the document itself is public information.
Okay, so you're saying there's a violation of 6721 for failing to provide the document in a complete manner?
I don't think we need to find a violation so much as compel them. I mean, we've already found a violation for 6721. it's still under 6721, so that would be a redundant violation at that point. I think we already found a violation for 6721, and now under 6721, we're compelling it to turn over these
But
documents.
when the motion that we just passed was specific to timeliness, it was not to completeness.
Correct.
So in order for you to compel them and ask them to complete this request, we would have to have a finding under 6721 that their response was incomplete. So that would need to be part of the motion.
Okay, that's outside of my understanding, but if that's the way it works, then...
Or there might be another section that can be used for this motion, but.
Yeah, it's,
Okay, so under 6721E, upon determination that the record is public, the Sunshine Task Force shall immediately order the custodian of the public record to comply with the person's request. If the custodian refuses or fails to comply with such an order within 5 days, shall notify the district attorney, attorney general, blah, blah, blah. That's the compelling part.
okay, but so going to the discussion of if we have to find a violation or not, that sounds like if we just determined that the records are public. So I don't know if we have to find a violation to ask them to produce it.
Then I think that was unclear with the motion. My vote was on a motion that they did not timely respond
Right, and that-
to the petitioner saying that these documents cannot be released for these specific reasons.
Correct. That was the...
That's different from that these documents need to be turned over.
I think that the motion, if we make a motion that these documents are public, the actual language under the motion that they're public would compel them to have to turn them over.
That wasn't the motion that was made.
No. This would be instead of the motion yes, we have a motion that we voted on. In terms of unwinding this current motion that hasn't been voted on, if you just make a motion to find the documents public, then that would activate the requirement that they have to be turned over. You don't have to actually find a second violation. Can anyone?
There are documents that are public records but cannot be turned over for specific reasons. For example, this document might be a public record. That's why we're listening to this case at all. But there are specific exemptions and reasons why these documents have a basis for withholding.
Right, I understand that. But under what I just heard read under 6721, by filing an explicit motion that this document is public, it seems like that would activate the order to turn over those documents within 5 days.
Unless there's an exemption.
Basis for withholding.
Right, but the exemption cited was for the information, not for the document. And that's what the whole discussion previously to this had been.
Okay.
Right.
So I don't know the precise wording, but 6721E seems to say that if the task force determines that a document is public, it doesn't say the information, it says the document, correct?
Upon determining that the record is public.
So the record might be public, but there might also be a basis for withholding the document. That is why some documents don't get turned over.
Right, but what they cited was not that the document should be withheld, is that the information was confidential. So if they redact all the information, they can still produce a document.
So you can make that motion, but it needs to be that specific motion. That's what I've been asking.
Okay.
So.
But you've been asking for a violation, and I don't know that there needs to be another violation.
So I would say make the motion.
Okay, so I move...
We can deliberate the motion once it's on the floor.
That under 6721E, that these documents are public and that they should be turned over in a form that the department feels, that the document should be turned over.
That there's no basis for withholding the
That there's
document.
no basis for withholding the document.
Okay.
I'll second that.
Okay, moved by Member Kanata, second by Member Josh Wolf. I just want to make sure our administrator got that. Okay, great. All right. Any further debate or deliberation on this motion? Public comment. Is there public comment other than the parties on the motion? Seeing none, please call the roll.
Member Wolf.
Aye.
Member Wolf, aye. Member Kate.
Actually, please call Member Kanata first because he was
He made the motion,
the maker
yeah.
of the motion.
Member Kanata?
Aye.
Member Kanata, aye. Member Wolf?
Aye.
Member Wolf, aye. Member Kate?
Aye.
Aye. Member LaHood?
Aye.
Member Tesfaye?
No.
Member Hensy?
Aye.
Member Hensy, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
Thank you. Sorry? Yes, let's refer to complaints and amendments. With the request that it be referred to compliance amendments, that they provide, well, I guess in this case, that would be the case. They're provided in the way they feel that they should be provided. We can't demand that it be redacted if they feel or they determine that it needs to be redacted. That's in their purview. We shouldn't make that determination for them. No, our motion is to, our action is to compel them to produce the documents. If they do not want to produce the documents, a different question. If they produce the documents but they're redacted, that it's their prerogative. If they produce the documents without them being redacted, that's their prerogative. We're not providing any direction as to how they are to produce the documents, just to produce them. That's all. Okay, is that clear?
And they would be produced for both the task force and the complainant? Is that who needs to get them?
They would go to, that's why we're referring it to compliance and amendments, so that they would be provided to the committee. And
Right, but they'll provided through to the SOTF office as well as the complainant. That's all I just wanted
Yes,
to.
that's, however, it would come through our means, okay? All right. Thank you very much, everybody's patience. I just want to go through the rest of the cases that we have here to make sure that we have all parties. Department of Public Health is still here, great. Mr. Roddy is still here, great. And is that the only one? Mr. Chan. Oh, Mr. Chan. Is Mr. Chan here?
I do not believe Mr. Chan is here, and the department has stated that they are ill today and were not able to attend and
Okay.
requested a
And
continuance.
what about this Walker Reed thing?
They are present.
Okay.
So, Mr. Walker, are you here? Okay, yes, okay.
And the department is present, I
And the
believe.
department, MTA is here? Okay, great, thank you. Okay, so members, what would you like? You want to forge ahead for one more? I need to take a break. I can pass the gavel if you want to continue on. I need to take a break. I want to take just 10 minutes.
We have two items left on the agenda, correct?
We do, yes.
I think that going ahead and taking a short break rather than trying to push for one more, because after one more, I think we're all going to want that break, and then it's kind of silly. So,
all right. So we beg the party's indulgence if we could take a 10-minute break. We'll reconvene at 7:14, something like that. 7:16 or somewhere around there. 7:15. Thank you. We're in recess.
One in the middle. Hit it again. Tap it. The pause should come up, the two bars. Hit it again. Not pausing.
Just tap Kane.
Well, maybe. Take a look at it in a minute, make sure it's moving.
Yeah, well, that's what I'm.
254, make sure it moves.
No, we haven't seen Mr. Chan, so.
Oh, okay. All right. So we'll do number 6.
Good, just two more items. Yeah.
Okay, we're reconvening. Okay, let's move to item number 6.
Item number 6, file number 18024, complaint filed by Patrick Roddy against the Department of Public Health for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner.
Okay, for this one, CNA.
Yeah, it's the same issue with, state law superseding where the Department of Public Health can't give out the records. They have to come from the state.
But this is specific to death records and not the indices, right?
Correct.
Okay. Very good. Okay. So let's have the complainant first. 5 minutes. Mr. Roddy, please wait for the clock.
So,
Hold on.
Oh, he's fine.
There we
He's
go.
fine.
okay, so this is about getting records about hospitals within the Department of Public Health, the General, Managed Care, Laguna Honda, because the state is obviously off limits, it would seem. I was getting lots of static on that. So a hospital knows how many people are in it, knows how many beds there are, how many staff are working, what visitors are coming and going, how many light bulbs there are, how many bed sheets and so on, and how many people are living and dead at any one time. So I took that approach. I should mention that I did get the data that I needed for my study from the coroner and Department of Emergency Management. But the point I am making here is it is very important that the public have access to death records. The fact if someone dies, if there's an epidemic going on, we have to have some way of ourselves finding out about it and not having to wait until the Department of Public Health, CDC, or someone else does it. It has to be local. It has to be independently verifiable by you and I. And the state system, if you get data from the state, you must destroy it. It is not repeatable unless the next person then goes to check your numbers and say, oh, that checks out, and then he has to destroy it, or he or she has to destroy it. This is unreproducible. It is worthless information, and this has to be done. It is really a matter of life and death. Yes, I'm talking about, whatever's happening, is the activities with geoengineering affecting our health, but we need this for future things that come up. The next epidemic, whatever, next AIDS, if we can't do that and have to trust the government, and having the government, giving them the power to withhold if anybody died or what they died of is extremely dangerous. I don't need to spell that out. So here I am. What I recommend is, of course, there's clear violation, for timeliness on this one, and I did not get the information. The hospital themselves know whether people have died or not, and yes, they also will enter this data into a database, but that's not the only record. If somebody dies, there isn't just someone who mentions something in a database and they leave the deceased in the bed. There are procedures in place, and for all of these things that are public records, I need those. I already have them, but I need to make the point that we must be able to get this information. It is really a matter of life and death. And I understand that the city's hands are tied in compelling the state to produce property that they claim to be their own. But I think from now on, the city should be collecting its own data on mortality. Because having it something this important, leaving it up to a third party, and frankly, the city is above the state, which is above the federal government. we decide finally what we should do. And I mean, all the arguments I've said many times, but I urge you to rule this violation. I found out today that they did actually send some stuff recently, I'm not sure when, which is aggregate data, which is not by day. I haven't even opened it up. It's worthless. I need stuff by day. I'm not going to say, oh, and so died of such and such. I'm not doing that. I'm responsible. I'll follow I'm not going to blow anybody's privacy. I'll be respectful. But this is extremely important. We do not want to be at the whim. I mean, you don't want to have a government being able to hide whether someone died or what of. I mean, the 20th century had lots of regimes where that happened, and they weren't pretty. This is open. We should use sunshine. We need truth. So that's my bit.
Thank you, Mr. Roddy. Are there any persons or witnesses providing facts or evidence on behalf of the petitioner, the complainant? Seeing none, respondent? You have 5 minutes.
Good evening again, Linda Acosta from the Department of Public Health. And we have given what we can to Mr. Roddy. It's not what he wants, but it is what we can give under HIPAA law. So we are unable to give records that would allow people to identify people who have died. So what we have given him is by month from May 2002 through February 28, 2018, which was his request, by month, the number of deaths at our two hospitals, Laguna Honda Hospital and San Francisco General Hospital. Was it in the most timely way? No, but we have provided all of the information that we can provide him at this time.
That it?
That's it.
Okay, thank you very much. Are there any persons or witnesses on behalf of the respondent providing additional facts or evidence? Seeing none, members. Lots. Let me ask Mr. Roddy, you did receive some documents, right?
I just opened it up now, and it says how many, it just says date, death, year, month, time. So 2002, in May, 25 people died somewhere, and so on, up to...
So the thing I'll say is that the fidelity or the quality of the data we have no control over.
Right.
Okay? The point is our question is, do any documents exist? Are they withheld, being withheld or not? And if they are being withheld, why? Okay? So that's what we have to determine, and it's going to be the scope for this case at this point. I had a whole line of questioning for it prior to hearing that documents were provided. I'm happy that you got some.
5 minutes ago.
Okay, but I'm happy that you got some. So then let's deal with some of the other issues. Yeah, Member Tessler.
I have a question for Mr. Roddy. Do you feel you've had enough time to review this document these records in order to determine that they fulfill your request?
I can show you them right now.
I mean, that's up to you, and you've only had them for 5 minutes. So I don't know. Do you want us to hold this item?
This is completely. It's a record.
Okay.
But it is not what I asked for, and it's incomplete. It's I asked for by day by hospital. I'm getting by month. No, this is I was specific. Just knowing, oh yeah, there were so many people died on a certain date does not violate HIPAA. And if it does, there's a problem with HIPAA. And frankly, the city is sovereign.
So would it be possible that like the record that you have that says that 25 people died in this month, they may not have even died at a hospital, is what you're saying?
We don't even know. It doesn't say.
Which means they're not responsible.
All I have is year, month, number. Okay. I don't know if it's people. I don't know if it's at Laguna Honda. I don't know if it's at San Francisco General. I assume San Francisco General. I have no idea. It's a bit light.
Member Kate.
Mr. Roddy, what form, you said you had records, what you were looking for were released to you from the coroner's office and another...
Office and Department of Emergency Management.
What form did their responses, I mean, what did it look like?
Complete.
So it had the...
I got everything I needed, yeah. What I asked for. I got names, ages, genders, cause of death, underlying cause of death, date, age, I got all that.
The hospital?
Not the hospital, but I have that. Because again, I'm not gonna violate anybody's privacy here. I'm doing research, but I need to do it from verifiable sources, which I don't delete afterwards. And I also have from Department of Emergency Management all the 911 calls that came in with for dating up for the last 3 years, and maybe a little beyond, plus the codes. So whenever someone called in with a medical emergency, what sort of medical emergency, what the paramedics found and reported back, I have all of that. But my point is, the Department of Emergency Management, the place where you think to go to get this stuff, is completely stonewalling, and they may feel they have good reason. But if they do have good reason, something's deeply wrong with this system. The counties must get this data back from the states. This is a very, very poor thing. Because the states are bad, the CDC's even worse. So at this point, I'm really just making a point. We need to have truth and openness about this for our own health, for our own safety. And how we go about it, I'd like to make a recommendation that public health start keeping its own records again, so that we have some control over this. I mean, of course, we're not going to say, oh yeah, so and so died of some embarrassing thing. I mean, that's not the purpose of this. This is
Just and one of the your description of the information that the coroner's office and Department of Emergency Management gave you sounded like a little bit more than, and I understand we're looking in this complaint at the request from February of this year, which I believe are the dates, times, unique record numbers for each of those 3 hospitals. Did they give you that particular information, or it sounded like some of that information might have been from...
I've got months and numbers, which I think is from San Francisco General. I could confirm it, I don't know. Which is frankly useless.
Is there what's the title of the spreadsheet?
Member LaHood.
The title of the spreadsheet is Sunshine Request 18-603.201.18.0321. And there are 3 columns: date, death, year, total, date, death, month. The total is just 8,000. Anyway, 3 columns: year, month, count.
So I believe we heard earlier that it was an aggregate of both hospitals was what she had said that she had provided based on month. Like, I think we heard a description of what it was earlier before now going over it.
Okay. All right. Is there any other questions, clarifications? Okay. Thank you, Mr. Roddy. Thank you, Ms. Casa. Shall we move to rebuttals? Okay. Ms. Casa, you're first. If you have any rebuttal, 3 minutes. Please start the clock. 3 minutes.
I did want to add for the record that we did provide these records to Mr. Roddy on April 9th. So, not just now. He's just opening them now. And they were for both San Francisco General Hospital and Laguna Honda combined. That was all.
Thank you. Mr. Roddy, rebuttal, 3 minutes. Reset the clock, please.
For a summation.
This is a rebuttal.
Okay.
If you have anything to provide.
Tonight I got an email from, it's from San Francisco Public Records. I've had one before. I had no idea if it was spam or not. I had no contact email from Department of Public Health saying, oh, by the way, there's this thing set up, so are you going to find it? It could have been a phishing thing. So it could be the case that that was sent. I had no idea. I get plenty of spam as it is, and frankly, it's you know, it's not great information. But really, I think I'd reiterate that we need to get control of this data back in the control of the city. And I would also ask the task force to compel the Department of Public Health to produce more complete records, daily records, at least. That's not going to identify who died of what, but I need better information than this. This is a little lacking. So yeah, that's it really. You know, I get speechified, but I'll say it's been a long night, and I'll save it. All right, thank you.
Thank you. Okay, is there a motion?
Sure. I mean, the original request was sent February 26th. The response was sent April 9th, so there's definitely a violation for timeliness.
Motion.
Sure, I'll make a motion for a violation of 6721 for not providing records in a timely fashion.
Second.
By Member Canada, second by Member Hinsey. Second by Member Hinsey. Any discussion on the motion? Any public comment other than the parties for the motion? Seeing none, please call the roll.
Member Canada?
Aye.
Member Canada, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Josh Wolf?
Aye.
Josh Wolf, aye. Member Kate?
Aye.
Member Kate, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Tesfaye?
Aye.
Member Tesfaye, aye. Chair Wolf?
Aye.
Aye, the motion passes.
Please call the next item. Verse 7. Oh, is that right? No, not item number 7. Yes, item number 8.
Not
Sorry.
yet.
Oh,
Number
did we
8.
dispense with item number 7?
Well, item number 7, let's call it and see if the parties are here, and then we'll move quickly to the next one. What? Are they?
No, they're fine.
Yeah, it's okay. Go ahead, please call number 7.
Item number 7, 180, file number 18050, complaint filed by Don Chan against the Juvenile Probation Commission for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and/or complete manner.
Okay, are both parties here? Mr. Don Chan and Juvenile Probation Commission? The parties aren't here. Members, how do we want to dispense with this? We want to put it on hold, on file? We want to continue it to the next meeting.
Did we hear?
Oh,
We did hear from the respondent that they had a medical emergency and were unable to attend. We did not hear from the complainant. However, we did.
I did send an email to the complainant. I did send an email to the complainant stating that there was a medical emergency, but as of 3:15, I hadn't heard anything from him.
Okay.
My suggestion would be to continue it as they may have to do that as a
Okay.
request for continuance.
All right. Is there a motion to continue?
So moved. Second.
Moved by Member Josh Wolf, second by Member Hensy. Any other discussion on the motion to continue? Any public comment on the motion to continue? Seeing none, can we take that by acclamation? Seeing no objection. Please call the next item. The item is continued. Please call next.
Item number 8, 18058, complaint filed by Deontay Walker and Tamara Reed against the San Francisco Municipal Transportation Agency for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and/or complete manner.
Okay. EOT. Do you have a brief for us, Member Josh Wolf, Chair of EOT?
Sure, let me pull up my notes real fast on that one. Sure. Hold on. Here we are. So, where are my notes? Apologies. Yeah, we have a case that it pertains to an employee matter of an SFMTA worker who I think they may at this point be a former employee. There was some sort of dispute over some sort of employment matter, and they requested the AWOL documents about the policies regarding absent without leave. They did not receive those within the window provided under the law, and I believe they were trying to get some additional records when we heard from the case. We found jurisdiction and moved the case to the full SOTF.
Okay. Ms. Reed and Mr. Walker, if you'd come up to the microphone. You are the petitioners / complainants. You'll have 5 minutes to present your case. Hold on a moment. Oh, yeah, there's microphone. Please prepare the clock. Great, you have 5 minutes.
So basically, we went into SFMTA April 5th and requested some documents. One of the workers, Young Lawrence, he denied us access to those documents for a few different reasons. So the next day, April 6th, I sent out an email to Donald Ellison and a few others on his team, letting them know about the incident we had, and then asking for those documents. We didn't receive any response, so I sent another follow-up on the 12th of April to the same people asking, is anyone going to respond? By the 16th of April, got an email from Mike Helms. He is the labor and employee relations manager, and he said that he would be he looked into it and he took appropriate action. At that time, I asked him, what that meant for Deontay or myself asking for those documents, and, what would be the outcome. He emailed me again on the 19th, asking me again, what do you need? So at that point, I sent another email on April 25th. I emailed him again to follow up about the initial stuff and a few other documents that I had needed, and emailed back saying that he has to gather them and I should get them by Friday or whatever. That didn't happen, so I ended up sending another email, and then on the 27th of April, he responded saying it'll be ready by the close of business that Wednesday. I don't remember exactly which day Wednesday would be, but I responded and asked if it would be ready by Tuesday because I actually needed it that Wednesday, and he told me it would be ready for review. On the 8th of May, I met with Caroline Salea at her office. I told her about the email, the request that I made, and she told me that, she sent me an email saying that she wanted to, I guess, get more time, because by law, they had the right to ask for additional 2 weeks to give them time to get it. I explained to her that my original request was on the 5th, and she asked me if I had documents of that. I sent her the original email, and she told me about the Sunshine Ordinance, so I filed the complaint, and since pretty much then, I haven't had any response. I did, however, get an email, the hearing on April, he got an email August 22nd, the day after we came here, asking what we needed, and then, it took us some time because we've been dealing with other stuff. So I responded to that email. This date, we haven't received any response, but Saturday, a certified mail came with some documents in it, and then my dad got the mail, but we weren't there, so I didn't get it until Monday, and some of those documents weren't exactly what we asked for. Some were missing. We were told that we have to contact another person in order to get some of those documents or to view the file. The contact information wasn't provided. We weren't able to kind of thoroughly go over these things. And, if these things would have been provided to us in April, here we are, 6 months later, and we still don't have everything. And some of the stuff they're saying there's no such policy. Some of the stuff that they did provide to us over the weekend, isn't exactly what we were asking for. And there's also a document, which is the original DWC form, which is the worker takes her, they make their workers' comp claim form. The form we asked for was the original form, and the form we received was pretty much a copy that didn't have a signature from the person who originally signed it. It was just basically blank as if you filled it out or it was redone. So, we're here because we did not get the documents. Their response to your office was, we didn't know that this was a public records request, but we did get it to you guys in a timely manner.
Okay.
Thank you.
Thank you. Are there any persons or witnesses who provide any facts or evidence on behalf of the petitioner, the complainant? Seeing none, respondent.
Good evening.
One moment. Reset the clock, please. Go ahead.
Good evening. I'm Don Ellison, Human Resource Director for MTA. And I just want to point out the individual that was working directly with Ms. Reed, Mr. Walker, was ill today, so you get me as a substitute. But she left me all her notes, and with your patience, I believe I can answer any questions. Again, there was, when we're in the education, outreach and training committee, there was some dispute on whether we gave documents to them or not, and we were saying we did, and they're saying we didn't. We provided those actually to the committee, but our direction leaving that committee was to get with them and hear exactly what they're looking for from us. So at post that August 21st hearing, on August 22nd, we sent out a request saying, tell us exactly what you need from us. And on September 12th, Ms. Reed sent a list of 9 items that she said that they want from us, 3 of which were never in the original request. So there was approved leaves, so we provided the approved leaves. Number 1, there was approved leaves. Number 2, vacation hours provided. Number 3, our AWOL letter. Number 4, they asked for a temp temp exempt disabled worker policies. No policy such exists. 5, they asked for DWC 1, which is the workers' comp. We did send them a copy, but that was not in the original request. They wanted clear copies of Mr. Walker's time cards. We provided. They wanted sick pay, vacation hour at all times on record before and after the leave. That was not in an original request. We provided those. They wanted his personnel file, which we cannot provide. We let them know that he can come in and request to review his personnel file. And the last one, her email, was a clear copy of time cards that were previously requested, and we provided those. So our position, we provided those things in the original request, per her email request, plus additional items that were not in the original request.
Is that it? Thank you. Are there any persons or witnesses provide any facts or evidence on behalf of the respondent? Seeing none, members. Member testify.
I have a few questions for the petitioner, complainant.
Ms. Reed or Mr. Walker?
I've been trying to note what documents are still outstanding. So right now, or could you just give us a list of what's outstanding?
So just from the list that he provided, the approved leaves in the system, he provided me documents.
Can you speak a little closer in the microphone? We can't hear you.
The approved leaves that he provided over the weekend to us were approved leaves that he filled out, like the return to work forms. It wasn't the actual document that we asked for. Like March 6th, 2018, we went into the office and we asked, what are the approved leaves that you have in the system, because they considered him AWOL. And we were getting a printed document with only 2 leaves on it. I wanted a complete list of what the actual approved leaves are and not the actual return to work forms that they provided, because we already have a copy of those.
Okay, so just to clarify what you mean, so they provided you with 2 pieces of documentation on leaves that had been approved, and you're saying there were more than that.
They provided the wrong stuff. So they gave me return to work forms that were signed, but what I'm actually looking for is this.
Can you put that on the
Overhead.
On the overhead?
To your right.
Well, she'll help you right there, so then we can see.
Out of the timer. Go from live feed to document camera. Left hand side.
I mean, I have a copy
Yeah, so we can see it. If you put it on the thing, then it'll show up on the screen we have over here. Okay. There we go. Okay, so what is this document again?
That document is his individual leave forms that are in their system.
Okay.
And that form is actually from March of this year.
Okay.
That's the only thing they had at that time. But we requested those things because they're saying that he was AWOL. They provided him a letter, which is one of the documents that says that he's AWOL as of February 2nd. But he has paperwork that says here that he's
On approved leave.
He's on an approved leave. But in that letter, it's also saying as of December of 2017, you're AWOL. But in the documents that they provided over the weekend, he's actually been in their system as AWOL since August of last year. So there's a lot of conflicting things, and it's like if we're asking for one thing and we've asked it to you in the beginning, now you're rushing to give us stuff, but it's not what we actually need.
And so what you actually need is, say it again?
This document, for this particular document, it needs to have exactly as you see it, but all of the approved leaves.
And so you're saying you know that there are more approved leaves. Is that why?
I don't know if there is or if there isn't, because they're saying we fixed it in the system, but we need to see that because, for instance, as you can see there, there's only 2.
Did they say that these are the only 2?
To our knowledge, they're telling us that he has been approved. Like, there's documents that already says that they changed his status in the system for the last 4 or 5 days that he was employed with them, but that was just for them to pay him out his vacation and sick hours instead of when he was actually an employee or afterwards.
Okay. So here we have 2 different instances of approved leave. are you saying that there are more instances of approved leave that should appear on this document?
Yes.
And are they arguing with you that there are not, or they just won't update this document to be?
Honestly, I'm not clear as to what their position is because they've said you're AWOL and then they're saying you're not. So I don't really know.
Okay. Okay, so that's one of the documents that you're looking for. What are the other ones?
There's also, he said there's no temp disabled worker policy. That is something that was asked to one of the workers, my parents, because we sat down and had a meeting with them in May. And we said, this is what it is. This is what you have, this is what it is. So our thing is, we need to see the documentation just like the personnel file. This is a personnel matter. Deontay has never been in trouble, he's never been written up, he's never gotten in trouble. So we need these things for something that's outside of your jurisdiction, but for his appeals with the civil service and his workers' comp. All of these documents have something to do with those things, but because.
So the disabled worker policy, are they saying that it does not exist?
They say they don't exist. So we're trying to figure out if it doesn't exist, how can you enforce that?
Yeah, can we get some clarification from the respondent on that?
To your question on the we call it the temp exempt disabled workers policy. Deontay Walker was under workers' comp, and his disability was workers' comp, so there was no need. There's no such policy, and all that information.
Wait, is there a temp and disabled worker policy?
No, not at all.
How can there's no disabled worker policy at SFMTA?
There's no temp. Yeah, there's no temp exempt. There's no policy whatsoever. Any issues around disability, the city policy on the disability, and on the workers' comp.
Sorry, say that again?
There's two types of leave. You can have a regular leave, which is city policy, and also workers' comp leave. There's not really any policy on temp exempt, period.
No, but is there a disabled worker leave?
There are
like
leave
taking
policies.
taking disability?
Right. There are leave policies, but there is no disabled workers policy. There are leave policies, which are the city leave policy.
And so would the city leave policy include disability?
Yes.
Okay, thanks.
But it's not called that.
Right, and you're right, and given access to the leave policies. And
Okay.
I want to talk about this document real quick.
Okay.
This is an internal work document, and the leaves which they received, their actual requests for leaves and approvals they received that cover these timeframes. I'm looking at the document for this first one. I have the leave document covering that time period, which is the request and approval for the leave, which we gave them a copy of.
Were there other approvals for?
Yes, they have. It's correct. There's 2 times that we have put in a request for a leave that was approved, signed by us and by Mr. Walker.
And so these are the only 2?
Yeah, yes.
Can I speak to Ms. Reed, please? To the petitioner?
Let me, I may be correct in that 1 second. I'm looking at the dates here.
Yeah, if you could confirm the dates, because she's saying that they have documentation of other approved leaves and other records of approved leaves, so I just want to get the record straight.
Yeah, there's 2. So we have the January 28th, looks like 2017 through March 5th, it was modified to March 5th, 2017. It was originally, that document that had 2/17/2017, it was modified to go to March 5th based on a doctor's note received from Mr. Walker.
And that claim was denied?
What's that?
That claim was denied?
Oh, no. These were granted.
Okay, then why does it say under comments that this claim is denied?
No,
That's the first one.
Okay.
it's not the lead.
Okay. And so perhaps the petitioner can show us in the packet other evidence that there were more approved leaves that should appear here?
So I guess the thing that is kind of troubling is, so that's the reason why I'm asking if there's more or not, because to my knowledge, we turned in, the issue is, we turned in all the documents. I personally was the one that turned in all of his doctor's notes to his department where he worked. And the department was saying, we didn't receive anything from you. So that's the reason why they considered him AWOL. But when we sit down and we have a meeting with them and with his staff, and they're saying, well, you were AWOL, you didn't turn anything in, but they show us documents that have February's date and we had to resubmit them, but they're said in May, they said they don't have anything from you. So that's the reason why.
Are those records in the packet?
This is what he sent us.
No, in our packet.
Probably not.
Okay.
We got this on Monday, technically Saturday.
Okay.
Because they said that.
Okay, hold on. Member Hensey? And then Member Joshua.
Are you saying that you turned in doctor's notes hoping / assuming that they would then grant him more, that they would then grant Mr. Walker more leave?
Yeah, so.
Okay, as evidence for approval of more leave?
Yeah, so what happened was, when he was taking off work, every time he got a doctor's note, I went to the division, turned it in. That happened from January when he got off all the way until now.
So I'm just going to stop you there for a second. When you hand delivered that?
Yes.
Did they make a copy? Did they timestamp it?
During that time, no. So then when they sent him the AWOL letter, because our thing is, if you know that a person's not there, why wait from March to December to say, oh, you're not there? You know he's not there because you expect him to come back. You were on leave. But I turned in the documents to them. They told us when we went to the Human Resource Department, they told us they're saying they don't have anything for him. What he needs to do is resubmit them this time, get them stamped, resend them in. So we did that. We did that probably 2 or 3 more times. And once we did it,
Did the record get corrected?
that's what we're trying to figure out. So we resubmitted them 2 or 3 times. They still, in May, to my knowledge, when we sat down with Mike Helms, he told us, they said you're AWOL. They don't have anything from you, but there's documentation here that says February 14th. There's stuff that says January, when they time-stamped it. So it's like, for you to say in May that you don't have anything, or he's not turning them in, we resubmitted them and you're still saying you don't have anything. How does that work? So then we went back to the Human Resource Department. The manager there in the Return to Work team sat with us again, helped us fill it out. She told us, this time what I want you to do is copy them, scan them in, send them in the email to his supervisor directly, and send them to us. We sent in that email, and still to this day, the supervisor or the Return to Work team hasn't responded.
Okay. Member Josh Wolf.
I think that it's important, and at least I think this is my understanding, that some of these documents, such as the one we're looking at, aren't in the packet because they aren't actually part of the public records. They're records of the personnel file that is available to the employee because of their status as the employee. I don't think this document we're looking at right now, I could just request for the mayor and see when they requested workers' comp claim. I think that this is part of the personnel document, and I'm not sure how best to navigate these two things. I think it's important that they get whatever documents they're rightfully allowed, but I think that the public records and the personnel files are kind of under 2 different auspices. In terms of the public records, it seems to me that with the exception of a policy that exists under a different name that they still don't have, that most of the documents that are listed that still are outstanding are related to the personnel file and not public documents. I don't know what our role in helping them secure the personnel documents are, but I do think that we need to look at these as 2 separate things. The public records documents that may not have been turned over under the timeline required, any public records that still don't exist, and then whatever we can do to help ensure that these people have full access to their personnel records, to use the public records to tell the story with the personnel records to build the narrative that they're looking for. But I think we do have to look at them as separate things.
Personnel records are public records. Are you in agreement with that?
I think the records themselves are technically public records, but the information contained in those records is only available because it's the person who's requesting them.
Right. Okay. All right. Member Hinsey.
Oh, I was just gonna ask, and I think you answered my question. So when you hand delivered these doctor's notes, did you happen to make a copy of them for yourself, for your own records?
We already had them, so it was in his like Kaiser file. So if we needed to get them, we could get them.
Okay.
Okay, great. All right. Anything else?
I have a few more questions. Going back to the AWOL documents, what are the AWOL documents that you need?
Away without leave.
So it's just the policy that you're looking for?
How does a person get considered AWOL? And that has yet to be answered or provided to us.
Okay, I wanted to ask SFMTA about that. Thank you.
On the AWOL document, the policy, each collective bargaining has a defined definition of what AWOL, what constitutes AWOL, and how it's to be handled in the discipline process. Have repeatedly advised them of such and said we can make that available to you. It's collective bargaining. We negotiate that with each union.
Right, so did you give them the AWOL policy for the petitioner's collective bargaining unit?
The actual MOU, absolutely. That was early on in the process.
Okay.
They're looking for a document, again, keep advising them that's in the MOU.
Okay.
Do they have the MOU? Do you have the MOU?
We have a copy of the MOU, but we were told I guess it's available online, but that MOU has no AWOL policy whatsoever. Like, what he provided to us over the weekend is a copy of the San Francisco's employee handbook and some of the documents, but neither one of those say how you can be considered AWOL.
Right, okay. For MTA, can you provide the specific AWOL policy that's located in the MOU so that you, instead of dumping a huge document, I know MOUs are hundreds of pages long.
There. It would constitute making a photocopy of those particular pages.
Okay, or scanning it, okay.
And one of the things I wanted to point out in this process, we're spending a lot of time talking about AWOL, personnel actions and discipline, whereas, we've been dealing with a records request. I understand their feelings about what happened on the AWOL process, what happened on his job, but we're responding to the records request.
Right, I don't think that we've been focusing on what his discipline or anything like that.
Okay, now, again, with the conversation about, I was concerned about the conversation with the doctor's notes.
Well, I mean, that's about a record of doctor's notes being handed in, not about whether they were legitimate or whether he was punished for not having the doctor's note. This is supposed to be the document on the screen is supposed to be, a record of the leaves that were requested based on doctor's notes. And if more doctor's notes were turned in for more leave requests, they should be included in the record. We're not trying to look at whether they're legitimate or he was disciplined or what have you.
Okay.
So I just want to make sure you don't think we're trying to do that.
And Ms. Reed was asking for confirmation that the doctor's notes that she submitted are, in fact, actually in the record. So she's just looking for what you have in your possession so that she can confirm for herself that she has them. Is that correct, Ms. Reed? Okay.
Yeah, and again, as you guys said, the records were saying that the lead documentation is here and was provided to them.
Okay. So, Ms. Reed, in our notes, I'm just going to rattle off a list of files, and I want you to just tell us whether you've received these or not. I want to make, or you can just tell us what you're still missing, and we can just go from there. It's up to you.
I think it would be best if you start from what you have.
Okay. So what I have here is you requested a copy of Mr. Walker's personnel file, which you probably won't get.
Well, he requested that part.
Right, but he'd have to go into the office to see that. Okay, good.
We were denied the access to that.
You were denied the access to it? Okay.
We were denied the access to that by my campus person.
Okay, and was that Did they give you a reason for that?
We couldn't see it.
Okay. That possibly is not within our jurisdiction. That probably is within your collective bargaining unit, that you'd have to deal with that.
That was another reason why a lot of these emails went directly
Okay.
to Donald Ellison, because he is my county supervisor.
Okay, so we can ask him about that in a moment. The MOU, you have a copy of the MOU? Okay, great. Timesheets for day shifts, switch repairs, and supervisors?
Yeah, he over the weekend, he sent it.
So you have those, okay. The AWOL policy, we just talked about that. Job classification numbers 7458 service list test.
Yes, he got that over the weekend.
Okay. Mr. Walker's workers' comp form signed by both Mr. Walker and his supervisor?
No, we got a copy of just Mr. Walker's signature, and the original form is supposed to have both of theirs, so I'm not sure how the document that sent us over the weekend only has Deontay's if it's a copy.
Okay, so no signature from MTA. Is that correct?
Right, it's not the original.
Not the original, not original. Okay. Mr. Walker's leaves that were in the system and vacation schedule.
So we still, so the leaves, like I said earlier, they didn't give us the list. All we have is what we actually got when we went in March. We don't have what we requested.
I'm sorry, so when you went in March, you got some documents?
This one that's on the.
Oh, okay, but you.
But we haven't received anything after that.
After.
Yeah, these are things that we requested in person.
Okay,
So you have this, but not an updated version of this, basically.
okay. And vacation schedule, same thing? Is that what that is?
Same thing.
Okay.
The sick pay, vacation hours, and all of his time on records before and after the leave, we were requesting that because part of his civil service stuff, he got, or received the remedy saying that they were gonna restore 104 of his sick hours. But they're saying, we're not gonna give you your 104 sick hours because you don't work here anymore. And you're not approved in the system. So that's another reason why we need to see what is he approved for, because when we met with Mike Helms in person, he said he was only approved for 30-something hours. But if you're saying, we have a more recent document from the Director of Transportation, Ed Riskin, saying we restored your 104 sick hours, but you can, from my knowledge, you will restore it only if he's approved. So where is the approval? That's pretty much we want to see, because they told us on multiple occasions they didn't receive anything even in 2018. They didn't receive anything from you. So our thing is, if you haven't received anything from us, where's the documentation? Because we have something even in 2018 that shows that we resubmitted these things to you guys, but you guys don't have an answer or anything that shows that we didn't.
Okay, so three things, right? You want the workers' comp form with both signatures? Okay, so the original. And Mr. Walker, do you recall being in the room signing it, and there's somebody else that's there that also signed it?
We had to leave it for them to fill it out, and they filled it out like 5 days later.
How do you know they filled it out?
Because originally we received a copy, but we misplaced our copy, so that's why we asked for it.
You asked for a copy of the original, you didn't get a copy of the original. Okay, all right. So then the next one is an updated leaves and vacation schedule.
So that is pretty much the first one, the approved leaves in the system. The sick hour, vacation hours, and all that stuff, is like I was explaining. We asked for those times, on record, what he had before and what he had after he was off the leave.
So you just want the complete record before and after.
Yeah, so if it says he had, before he went on leave, his last paycheck says that he had 30 or 50 sick hours, 140 vacation hours. Once he's no longer an employee is when they pay him out, so it should still reflect the same thing. And it doesn't, so that's why we're asking for what is exactly in the system. When he was terminated and he received his last paycheck stub, he received a manual paycheck stub that didn't have the correct hours. So we already had his last paycheck stubs from the system, and they didn't reflect the same. So
Okay.
we wanted to see what the discrepancy was.
And I guess it would be the fourth item would be the approvals.
The fourth item would be
Yeah.
the hours that he has on the books. So like vacation, sick,
Right.
those are.
Okay. Oh, okay, so that's part of the previous. Somehow I heard you say approvals being something separate. It's all the same. Okay, great. Okay. All right, members, let me just ask Mr. Ellison, is it possible that that original document, the workers' comp document, is that available?
Yeah, the original document is the one they received. There's no requirement that the supervisor signs it in order to start the workers' comp process. So more than likely, I'm only guessing this document came to our workers' comp division from them, and they started the workers' comp process.
But they said that they saw a document that had both signatures on it. They had a copy, they misplaced it. They requested a copy of the original copy that was signed.
Okay, I'll take a look at it.
Okay.
The workers' comp, our file, there's no super.
Okay, I think it would be appreciated
Okay.
if somebody can look into that. And then the updated approved leaves. So the document that's up on the screen is the first one. They want a current one.
Again, I'll say that's a.
Internal.
Oh, yeah, working document, the approved leaves, the actual dates and approval with all the signatures they received, which would be the request for, it's called request for leave documentation, where it shows the approval on those. They have received those.
They're shaking their head, they
They're
don't
saying
have
they're
them.
not, yeah.
The request for leave form is exactly what I was saying is not what we need, because this shows what they have in their system. That doesn't show what's actually in their system.
I see. So you're the difference between an intake form and the data from the intake form being inputted into the system.
Right, because you can say you have it, but that doesn't mean you enter it.
Right, okay, so they're looking for a report.
And I want to speak to we gave them all their hours, his hours for that whole time period, his employment time period. All that stuff is captured within here, and he's disputing the 104 hours, which I personally approved as just as a settlement to make this go away. And I'm looking at the documents to receive. He has months and months of AWOL and 3 weeks of pay, because I converted those 104 hours into sick time. So
Okay.
they have that information.
We're not going to adjudicate that part, but,
They got the information. I'm looking at it here.
okay, so let's get some confirmation. Did you get that information that he just explained?
We did get this document that he's talking about over the weekend, but again, that shows that there's a contradiction in the AWOL, there's a contradiction in the letters.
So what documents do you need in order to corroborate it for yourself?
This we need to know, one, the AWOL. We need to know, one, the AWOL policy, which we don't have.
Okay.
And two, if you're considering an AWOL in August, why did he get an AWOL letter in December, but in May when we meet personally with his staff, they say that's not an AWOL letter. So we're just trying to figure out where's the
Okay,
AWOL coming from.
so we can't,
Right.
we
so
can't
that's
do
what
anything
I'm
about,
saying.
okay.
We just need the documents to be able to handle it. on
Gotcha.
our own.
Okay. So, Mr. Ellison, do you understand what she's asking for?
Yeah, in a sense I do. I'm not sure when I can produce to, resolve that. Again, she's talking about,
It's not a matter of when. It's a matter of do they exist?
right, from the AWOL policy, the answer is the collective bargaining agreement, any other documentation on whether they were AWOL or they were not, or what the system said or who keyed in what, they would be listed right here and there would be no other documents.
Okay.
So the specific AWOL policy.
Right.
This
So,
is not the whole MOU.
right. So she's just asking, even if you just provided with a page number, if they have the whole MOU, you have the whole MOU? So, yeah, if you just provide with page number, it makes it easy. And then the other documentation, they want to be able to confirm the AWOL dates and the documentation that go along with those dates of when they were submitted. That's correct, right? Because there seems to be some discrepancy between what they have and what you have. So is there some way you guys can get together and kind of figure that out?
And I guess we can sit down and walk through this time. There would be no discrepancy because there are records, and these would be the official records, how we paid, how he tracked them. If she has something different, that would not be the official record.
Right, I understand that, but if she has some records that are valid that she got from the city, and then you have another set of records that you consider valid from what is being generated from your office, is worthwhile for you guys to sit down and figure out what the real story is. And if they need to contact their collective bargaining unit to sit in on, let do that. So we're only here to determine if first of all, are the records public? Do they exist? Who has what, where? That's all we're here to figure out at this point.
And I'm willing to do that, and I'll sit here and evaluate. We've always had a good communication relationship. So us sitting down and talking about it would be just fine.
That would be great. That would be great. Okay. Thank you very much. We can, any other questions? We move to rebuttals. Sure.
And I know, like you said, you guys don't have jurisdiction over the AWOL stuff, and that's not really what we're here for.
Pull the microphone.
My thing is, with the AWOL, and I know this is kind of repetitive, but he's saying there's no way to provide the document of how he became AWOL, or, there's no confirmation on their end, but these documents that we do have come from his office and from his staff, so if you don't have those documents, how did we get them?
Right. So that's what I was just asking him. If you bring your documents, what you have, and what Mr. Ellison's saying is they either have other documents or they don't have those documents. If you guys can get together and try to reformulate and correct the file so that it reads the way you believe it to read, or they can tell you how it's supposed to read. At least you'll be on your way, and you'll have a line of communication. You guys can work together and try to resolve the issue.
I mean, the biggest thing is, like I said, we just want to know how the AWOL came. The policy is there. We just want to.
Right. I understand. So the first thing is they'll tell you where to find the AWOL policy. You can determine whether it applies or not, and how it applies. And then you can take your records, corroborate it, match them up with them, and try to resolve this, get the right numbers in the right place, kind of thing, right? Okay. All right. Great. Is there anything else that you need?
I mean, he said there is no temp exempt disabled worker policy, or that should be an MOU.
He said it would be in the leave policy.
It's just called the leave policy, and all things regarding leave are contained in that policy.
That's what he provided the employee handbook over the weekend, but that wasn't clear.
There may be a section in there that says disability.
Yeah, look at the table of contents and index read.
Yeah, there may be a section because, there's a difference between workers' comp and disability.
Yeah.
Right.
So,
That was the thing, that since that's another issue beyond your office,
Right.
but that's one of the things that we were sitting down with my counsel about, is because they're saying you don't have approved leaves in the system, but then it said your workers' comp was denied, but one of his workers, James Scenario, who handles the return to work team, and Dan Roach, who handles the workers' comp team, both have two different views on, what we were told specifically from James Scenario: if you are not on approved leave through workers' comp, but you have a doctor's note, you're still on approved leave.
so if you have two different staffers telling you two different things, Mr. Ellison right here, he's the one that's supposed to arbitrate those things, right?
But he did not.
No, I understand, but we're moving forward here. So if we can get everybody in the same room, you could probably get it resolved. So if one employee says, hey, this is the way I interpret it to be, another one says, oh, this is the way I interpret it to be, there has to be somebody with a higher pay grade to finally make that decision, right? Okay. And that's why you have the head honcho here. Okay. Thank you. So we're going to do rebuttals. Mr. Ellison, you go first if you have anything anything else that you want to
I
speak
just
of?
appreciate your time. I'll follow your direction and get with Mr. Walker and work this out.
I appreciate that. Thank you. All right, Ms. Reed, Mr. Walker, do you have anything else to add? Okay, great. Okay, members.
So, I'd like to make a motion to find a violation of Section 67.21 by failing to respond to a request for public records in a timely and/or complete manner. I would also like to refer this item to the Compliance and Amendments Committee to make sure that we get some follow-up.
Second.
Moved by Member Tesfaye, second by Member Hinsey. Any discussion, debate, comments? Any public comment on the motion, not except for the parties? Being no public comment, please call the roll.
Member Wolf? I'm sorry. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Wolf?
Aye.
Member Wolf, aye. Member Kate?
Aye.
Member Kate, aye. Member Kanata?
Aye.
Member Kanata, aye. Member LaHood?
Aye.
Member LaHood, aye. Chair Wolf?
Aye.
The motion passes.
Thank you very much, and thank you for your patience and indulgence, everybody. Okay.
Chairman, I'd just like to request that the specific list of documents be listed in the order of determination.
Okay. Please just, it is a administrative amendment to just make sure all the documents that were being requested are listed, notated. Thank you. Okay. We have no more cases. I think we're up to the staff report. Item number 13.
Item number 13, staff report, complaints and communications. What?
You need iPhone? Yeah.
I'll go ahead and start it off.
Okay.
We have our tentative hearing schedule. I believe we have a tentative rules committee meeting for October the 23rd. We were thinking about 4 o'clock, and depending on member assignment, I believe that member Kate and member Hinsey are on that as of this time. I believe I'm not sure if Vice Chair Highland is a member of the rules committee or not.
Yeah, he is.
Yes, and we will ask him if he's able to attend, or we'll ask for a third member. We also have the complaint committee on that same day at 5:30. EOTC's meeting on the 16th. Member Wolf will need some members, or we could put that meeting off to a later time.
When is it again?
That's October 16th.
October 16. 3:30.
That's
3:30.
He's open to changes.
It's
It's scheduled for 3:30, but he's more than willing to change that time.
I think I can do it, I think. Yeah.
Okay, please, so who can fill in?
Send an email. I have to check with.
Okay, so.
I could not do it until 5:30 though.
Can't do it until 5:30. We're talking about the next EOT meeting.
Okay.
Instead of having it so early, you could do it later. How late?
I'm driving that night to LA.
Okay, so.
When do you want to leave by?
I mean, I was hoping to start it at, like, we normally start them at 3:30. I was happy to start at 4.
Okay.
But
If it's an issue, let us know what time, and we'll adjust the amount of items we put on the agenda.
I mean, I'm happy to, as long as I'm out by like 6, I'm fine, and even 6:30. But yeah, I don't want to be here till 8.
So we can adjust the agenda to match those times.
So, Member Hinsey, what would be a good start time for you since you're the potential alternate?
I can do 4 or 3:30, but I can do 4.
4 p.m.
Okay, great. Thank you very much. For
Yeah,
being
4 is
flexible,
great.
everybody.
And then we have the tentative rules committee for October 23rd. We have member Hinsey. I believe we have member Kate, and we will try to get a third member before that meeting.
Yeah. If Vice Chair Highland isn't back yet, then I'll sit in.
Yeah.
And then later on that same day at 5:30, we have the complaints committee.
Okay. That works.
The next meeting of the Sunshine is November 7th. The next two committee meetings are open to discussion as we have the Thanksgiving holiday right in the middle. We have November 20th of compliance and amendments and November 27th of the complaint. And we are on holiday from the 22nd and 23rd.
And
Would you like to cancel any of those meetings at this time?
When did you say that the CNA was the 20th?
I'm sorry.
Compliance and amendments on the 20th. I'll be here.
Okay.
Member Kanata, is the 20th an issue for you?
No, the 20th is fine.
Okay, I guess we will proceed with compliance and amendments. In regards to the complaint committee on the 27th, is there any need to cancel that? Okay.
I'll be here soon.
I guess we will go forward as scheduled. Just so you know, we are pretty much close to being no items to schedule for committee. We have the committee hearings are pretty much done as of this month, unless we get new items. It's just a matter of getting to the full task force.
Okay.
So we're very close to having nothing pending in committee.
Great. That's fantastic. I don't think I've heard that words before.
Yeah, I know.
Except for one person.
Yeah, one
Okay.
person.
Everything except for one person.
Okay.
That's one complainant, you mean?
Yes.
When you say one person, you mean one complainant, not one respondent.
One complainant. Yes.
Great.
And
Pretty much
that
one.
person, their items are still pending before the committees. However, there is a limit of 2 per person per department. So it's there's no way we're going to schedule all of them within the next year.
Okay.
As there's over 30 complaints by
Oh,
this
wow.
one person against one department.
Okay.
Is there a need for intervention? I'm serious. We've done it before. We've done
I
it.
don't believe it does any good.
I-
We've attempted
Okay.
twice in the past to resolve the issue, but it doesn't work.
And the complainant can't identify ways that those 30 complaints against one department aren't actually like.
Yeah.
We have tried multiple times.
I
Okay.
tried it last Friday to get her or this person to withdraw a complaint. She said she would, and then today she responded that she would consider it.
Well, but I mean, like, can't it just be like 7 items with semicolons, and then 7 items with semicolons, and then 7 items with
We
semicolons?
still have to talk about each individual instance separately. They're all separate instances of
Different things.
Okay.
Yeah.
All right, so, in these kinds of things, this is where we need a new rule in dealing with, multiple complaints against the same department, with individualized issues. I think there needs to be, if you start creating a limit, if that starts happening, and then there has to be a meeting of some sort to discuss how to pare that down. And what the task force will or will not hear. It's not like we won't hear things, but there has to be some, validity, I think. We don't need a reason, but at least we need to determine some level of validity.
I think somehow, if we are creating rules, we need to be mindful of the fact that, like, someone could file. How do we put this? We have a fairly diverse level of government sophistication amongst people that file requests and complaints. And I could imagine how a lawyer who's involved in some sort of class action case could file a whole bunch of different things that all connect together and isn't a situation of over. I'm just trying to figure out that we need to be delicate with the rule of reason too.
I agree. Well, there is rule of reason issue, but I think I don't know if it's this. If you can equate it in the same way, running a line of or a thread in a case before a court, you have to provide briefs. You do have to provide some inkling of where you're going and what you're trying to do.
Right, but I mean, like, someone could file 60 public records requests to different components of DPH that all connect up to a larger, sophisticated
Right.
system. And each of those requests to different people is denied for different reasons. And then so they file 60 60 Sunshine complaints because each of these pieces all actually adds up. And usually when that happens, it's someone that's sort of using a machine gun pattern, but I don't want to exclude anyone that actually has a legitimate legal strategy to pursue that way.
Quantity doesn't equal vexatious complaint, I guess is what you're
Right.
getting at. You can have a lot of complaints, and they could all be valid. And I wondered if there was some way in the, I don't know how this process all works, but in like the discretion of the chair, certain, regardless even actually of potential vexatious kind of issues, things could be put on a consent calendar for the full task force to consider, and then if there were 20 complaints and any particular member wanted to pull an item because there may be validity no matter who the complainant may or may not be, well, maybe, they could say, look, I actually, file 1802 or whatever, I want to pull that and I want us to have a fuller discussion, and the agenda would have all the materials for everything in the consent calendar. And if someone wants to have a fuller discussion on 1 out of the 10 or 1 out of the 5 or 20.
There just needs to be an action for consent. What is that?
Sure.
The
Right.
purpose of consent, to find a violation for all multiple items?
Oh.
Or?
And they each are required to, by our rules, there's the right, under our rules, they have the right to a formal hearing.
Right, the complainant has a right to a hearing on each of the complaints.
Right.
Could we just put
Right.
this on the Rules Committee agenda for further discussion?
It could be just
Right,
my lack of
yeah.
institutional knowledge, but
Right, that's why I was suggesting that there has to be a special meeting with that person. It's an intervention to figure out which items are the most important.
right.
Which, that kind of thing. Either prioritize them, out of 60, will 5 of them how far will the most important 5 will get you? It's like we're trying to help them solve the problem.
Right.
We're not trying to make a judgment on intent.
What is the department that is the defendant?
Arts Commission.
Okay, that's what I thought.
So,
Yeah,
and it's also
And I guess we need some clarity on what does it mean to have a full hearing? Does it have to be before the full task force, or would a committee be able to suffice? Because in other agencies that use a consent calendar, a hearing has occurred before like an administrative law judge, and then you're able to have it on a consent calendar for like commissioners to vote on. So in this case, maybe we need to look into whether their right to have a hearing, does that need to be before the full task force, or would a committee hearing suffice in order
Right.
to get it on the
And in that
consent
context,
calendar?
even with the multiplication of complaints that would be on a consent calendar, I guess that could be on the committee, chair or chairs, depending on where the complaints all reside, who could then make the determination of where basically how can I get this to the task force on a consent calendar, and if someone wants to pull it and say, you know what, I see that you have a timeliness finding, I agree with that, but I actually also think there's a more substantive response finding, and I want to pull that so we can at least add that.
We've gone through that stage in the past, and we were doing this. However, this current task force has eliminated that process.
right.
In the past, we have had committees have hearings and have it come to the full task force for consent, but that did cause issues.
Right, so I'm going to suggest something else, but
I was going to say that we changed that just recently, where the committees generally are there just to make sure that all the facts of the case are ready to be presented and not to make a recommendation.
Right, but I'm going to specify, this is a special case, okay? So when you have a special case, when you have X number or more complaints coming in from the same complainant against the same respondent, that there has to be, a special, call it a task force. There's a special committee that gets created to work that out. We already kind of have a rule anyway that we have a limitation on that, okay, which is supposed to flag the complainant that they're submitting too many, and that we will say, oh, okay, you only get this many, pick 5 or pick 10, whatever the number is supposed to be. And then that's the way that's supposed to go. I think that's a much better way to go, is we create the limit, and they need to figure out which are the most important ones that they need to have forward.
So, of the ones that are out there, what are the year ranges? I mean, how far back do they go?
About a
Majority
year.
is 2017. I would say majority is 2017.
Well, wait a second. I think a better question is, when were the requests made?
Okay, right.
Not how,
Usually they're in the same range, within a month or two.
but what year?
2017.
Oh, so these are pretty old.
Yes.
Oh.
Been put on hold
Oh, they've been, okay.
because
These,
we are only doing 2 per month or 2 per meeting, and so a lot of them are on hold waiting
Right.
for available hearing time.
oh, okay, so this is just from the one person?
Yes.
Oh, okay, that makes it a little more clear. Okay, so I think that we should just continue the way we do. Only put 2 on any one meeting, and then that person can determine if they want to continue with the rest of them or not.
Yes.
Okay? Otherwise, unless it's the pleasure of the body to try and help this person consolidate them and drop or withdraw some of them.
I have a question. Sometimes we have violations that are simple timeliness issues. The paperwork shows that it didn't get done within the calendar allotment. The department's like, yeah, we screwed up. Like, this happens fairly frequently. Is it possible to just go through and sort out any explicit timeliness ones that there is a record that the response didn't happen, and deal with those on a consent calendar where basically we just ask the department, do you agree that there was a timeliness violation on all of these?
But then you have to get agreement from the complainant.
Those we usually resolved on our level. If it's just a matter of it being late and they want documents, we work with them. They get their documents, and we get them to withdraw.
Mm-hmm. Yeah,
And we do that quite often.
Okay, so there aren't any just cut and dry, all of these were 4 days late situation that we could just
If they're willing
dispose
to
of.
accept the documents and be done with it, they usually withdraw, and we take care of it.
Yeah,
All right.
I know, and I know we're on record here, but there's in my opinion, there's so much personal animosity here that nothing is going to solve. There will be nothing that we can do to make this stuff disappear. So I'm kind of agreeing with Chair Wolf about let's do 2 in a meeting and just, go down that path.
It's up to 2.
Up to
You
2,
can do
right.
1, that kind of thing.
Mhm.
So, okay. What
Just
else?
to continue with the report, we have 1 pending complaint from 2016. That's the Ray Hart's item that we're trying to figure out. We have 23 from 2017. Majority is from that person. And we have 42 pending items from 2018. Our total count has gone down from 68 to 63. Next on the list is a list of ongoing issues, and I'm working with the chair on those.
All right, any questions for the administrators? Plural. But main administrator. Okay, great. Okay, any public comment? Seeing no public comment and there's no action, next, please call the next item.
Next item is item number
Announcements.
announcements.
Most important.
Item number 14, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Okay. Anything for the good of the cause? Future agenda items? Anything? Okay. All right, great. Any public comment on this item? Seeing no public comment, please call the next item.
Next item, item number 15, adjournment.
Is there a motion?
Motion.
Second.
Moved by Member Kate, second by Member Canado. All those in favor say aye.
Aye.
Opposed? We are adjourned.